Chowdhury? Nazir Chowdhury? Nazir A. Chowdhury, 25B82624A, B, and C. Your name, sir?
It's me, Greg Costello.
No.
Jawad Chaudhary for Nazir Chaudhary.
All right, good morning.
Good morning.
What's your name?
My name is Jawad Chaudhary.
Yeah, okay. Now, you said your father can barely speak, you told me last time, right?
Yes, that's correct.
Did you guys talk to the building department over there?
Yes, I have removed all the dirt. The only problem is I cannot do the front of the driveway is because I got let go from my job like a couple days after the last court date. So I don't have the funds to be able to do the repair. I'm applying for different jobs.
Second, sir. Hang on.
Sorry.
Taylor.
Can I have you come in here on this Chowdhury case, please?
Yes, sir.
Yeah, I can't put this off forever. You
Right.
follow me?
Yes.
I can't do it. I mean, I can't do it. This is, the citation was issued September 2nd. There's not been an arraignment. And I cannot let you represent your father. I thought we were going to get your father a lawyer. Lisa, did we set up the defendant with an attorney on this? I'd written
No.
down. All right, so I said adjourn 2 weeks, set defendant up with attorney. I need him to have an attorney.
Well, the defendant didn't appear, so
Yeah, I know. Well, the defendant can't appear, it sounds like. Your name?
I'm fully clear. I've been president township.
Your name?
Bob Harris on behalf of Brown South Township.
Did you go out and look at this property? Tell me it's in good shape or it's at least getting better.
All I did is move everything to the back there.
You can't do this stuff. Listen to me.
I tried to put it in a storage.
Hang on.
but-
Hang on.
Yeah. Photos taken from when the citation was issued and from yesterday. If you'd like to see them.
I need your father to appear on this. He is responsible for this. I'm sorry that he's ill, right?
Yes.
I'm sorry that he's ill. What are these bags of?
Been soil around.
Why didn't you get the garden soil out of here? What is going on? They still sitting there?
They're now in the backyard, which isn't any better than one before.
I plan on moving them to a storage facility. But the
Mr.
thing is,
Chowdhury,
I got fired.
Mr.
so-
Chowdhury,
Yes.
Yeah, that hold on. Take it out. Dude.
who wants to look at this junk? Who wants to look at this junk? I can't believe this junk was sitting across the front yard and on the driveway like this. I mean, I don't know. Maybe if you didn't live anywhere within 10 miles of your neighbor, it looks like there's houses right next to you, behind you, everything else. Who wants to look at this junk? I'm not going to play games on this. I'm telling you, I'm not going to play games on this. What else is the problem besides these bags?
There was a fence installed without a permit. And there are weeds and other,
The driveway,
I can see there's all kinds of weeds in the driveway.
well, the driveway's unsafe, that needs to be.
Well, repaved. Yeah, you can see that unless somebody wants to break their legs. Mr. Chowdhury,
Yes.
you're gonna force me to get tough. I don't want to get tough.
I'm not, I'm not trying to.
Mr. Chowdhury,
Yes.
I want you to understand me very clearly here. This is going to get done. The only
Okay.
question is how painful is it going to be for your father and or the rest of your family if you do it as at your pace as opposed to mine? Okay? You have to apply for permits when you erect fences. You can't have junk all over. This driveway looks like a bomb shelter. I mean, it looks like it's been bombed, I should say. Not a bomb shelter. I don't know what to do short of requiring his father to come into court. How old's your father?
80 something.
Well, that's not too old. I mean, is what kind of an illness? Why can't he come to court is my question.
Diabetes, health issues. He can't stay awake.
Well, you're going to have to bring him to court next time, okay? If you want to make this painful, I can make it painful. I don't want to make it painful.
I'm not trying to make it painful. I
Well,
just
you
lost
need
my
to do
job.
what I told you to do. Listen,
Okay.
I'm adjourning this 2 weeks. Your father's coming in person. If I get a note from a doctor telling me it's unsafe medically for him to do that, then I will reconsider my decision, and I will obviously not do that. Lisa, give me a time in 2 weeks. I want him to have a lawyer, appoint him a lawyer. There has been even no arraignment yet because Mr. Chowdhury here, Jawad, has been showing up. I believe I had his father on camera. So what is that, the 5th?
November 5th at 10.
Take your pictures back, please. I want everything taken care of. You're going to have to apply for the permit. You're going to have to get a
Okay.
hold of the building department. We're going to have a lawyer for you. You're going to have to bring the father, defendant to appear in person.
Okay.
Don't make this hard.
I'm not trying to.
Well, you kind of are. You kind of are. You guys start erecting things without permits. You move the bags just to the back. You got a driveway there that looks, it's more of a hazard than anything is what I'm worried about. I'm surprised the mail ladies haven't, or mailmen haven't fallen down and broken their necks. We'll see you back here. I expect him to be here. Do we understand one another?
Yes.
Lisa, that's to be in person, all over that. Thank you. I don't know what else to do on that one. I'm sure Mr. Boyd here is not going to be an easy one either. I'll call you when that case is ready. Thank you. Istelart. David Istelart Gonzalez, 25W836-565. Mr. Istelart? Your name, sir? You have to start your video and state your name.
David is still art.
All right. So I've got a charge, and it was fair to attend the court work program on September 27 of 25. I adjourned it and said you could appear by Zoom. Again, I'm going to offer you the right to a lawyer if you want one. Would you like an attorney?
No,
Do you wish to have a hearing, or do you intend to plead guilty on this?
hearing.
Okay, let's get in Ms. Tassino in here, John, real quick, and we will have that hearing. Okay, the charge, again, you understand, is fair to attend the court work program on September 27, 25, correct?
Yes,
All right, and you know that I entered a not guilty plea for purposes of arraignment, correct?
Yes.
What's her number again?
We are calling. She said she's wrapping up an appointment. She'll be right in.
Mr. Estolart, you just stay right there. I'm going to go on to another case. The probation officer's finishing up an appointment. She'll be right in. You can just stay right there. Derek Paul Lopez, 25B149536 A, B, and C. Come on up to the podium, sir. Your name?
Derek Paul Lopez.
You're charged with disobeying a police officer, directing traffic, resist, hinder, and obstruct an officer, and also careless driving. Ma'am, can you have a seat? I'm sorry. Can you do that, please? You have the right to a lawyer. You have 3 charges here, 2 of which are misdemeanors and 1 of which is a civil infraction of careless driving, a 3-point violation. Do you understand that? Would you like an attorney to represent you? Okay. We'll set you up with a lawyer. You can go out in the hallway and you will just be patient and you will be appointed a lawyer. But I do have to say you have another charge here from the same date. It's 25B149537, which is defective equipment window tint. So 4 files. We're setting you up with a lawyer. You go out in the hallway and he'll bring the file and get a lawyer to you, okay? Just be patient. Thanks. People against Baldridge, Miranda Rose Baldridge, 25B149433 A and B. Baldridge here? Come on up. Your name, ma'am?
Aldrich.
You're charged with a misdemeanor offense of leaving this. Where's your lawyer? Is Mr. Zayed here? Lisa?
No, not on Zoom. That file should have been with Caitlin until he came in.
Okay. Ma'am, go have a seat, okay? Thank you. All right, Jen, this has to go with Caitlin. People against David Istolart Gonzalez, 25W836565. Your name again, sir?
David Estolart.
Ms. Tessino, your name?
Emily Casino.
He pled not guilty at the initial hearing. I don't remember why I adjourned it. I think you might have been out.
Here, I just didn't get in for quick enough.
Well, we're prepared to go with the hearing. Are you ready to testify?
Yeah.
Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
Definitely.
All right, go ahead.
I have the report right here for the court work program dated September 27th of 25. He was a no-show. There is a note that he showed up at 8:55 a.m. But because he was late, they locked the doors at 8:35. He was not permitted to work. Therefore, he wasn't able to complete the court work program day.
Do you have any questions of her? Mr. Istolart,
No.
do you wish to testify or remain silent?
Testify.
Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
I agree. Yes.
You do?
Yes.
Okay, go ahead. Tell me what you'd like to say.
There was a car accident which was completely out of my control, and I had to circle around trying to get there. I know it's just a 5-minute thing, but I did show up there.
Where was the accident?
I think it was around before 4th Street, and I'm not from the area.
4th Street? What's 4th Street in Trenton?
No, not Trenton. I don't remember the name of the street, to be honest.
Well, why were you 25 minutes late? That's a long time.
No, I don't know why it says that. I arrived at 8:40.
Who wrote 8:55?
Yeah, I don't know what supervisor was working that day, but he said he showed up late around 8:55.
All right.
He was notified that he could not work today.
No, and he even told me we're on camera. So I'm pretty sure I checked my watch. It was 8:40.
I'm going to find you guilty as charged of failing to attend the court work program. You have to get there on time. I will have you do anything else you'd like to say? That's your first technical violation. Anything else?
No.
Pay additional costs of $100. Serve an additional day on the court work program. So you're going to have an additional day to be on the court work program. You want to talk to him and pay $35 for that. So you owe $135.
I'll send an email.
All right, she's going to email you. You owe $135. Can you pay that today?
No.
When can you pay that?
Can it just be added to the tab?
He's not a payment plan.
Well, $100 weekly?
I have expenses.
Yes.
Lisa, just add that to add these fines costs in system and he can pay at the same rate, okay? All right, that's what I'll do, Mr. Delark. So she's going to email you and schedule your court work program. Did you say something, Lisa?
Yeah, just so you know, he's not up to date on the payment plan. He's making $1 payments, it looks like.
$1 payments.
He paid 100 on September 15th, and then we received $1, another $1.
What? $1? You paid $1 on October 14th?
No, I paid 100.
When did he pay his first 100?
September 15th.
And they paid 50 on October 7th, right?
Yeah, and then $1 on the 14th.
Why would you pay $1?
Then I got $1 again on the 21st.
Why would you pay $1?
No, I just click and pay the $100.
We'll check your bank account, sir. Maybe you can see what happened.
You're saying you made two $1 payments.
Yeah, I have a $1 payment on October 21st and a $1 payment on October 14th.
I have the payments on the screen, Judge.
That's what it says. Restitution on your credit card. Why would you pay $1? Tell me why you would pay $1. I just want to know why somebody would go on a credit card and pay $1.
No, I need to check on that, but I clicked and I'm pretty sure it said 100. I don't know why it said $1. I don't know if there's a hold on the credit card or something.
A hold on the credit card? What do you mean?
Like a pending charge or something before it releases the money. I don't know how that works. But I paid $100 online.
Well, you better provide us with proof quickly. So I would check that now. Are you working?
Yeah,
What time? Today?
since 7 a.m.
You're at work now?
Yeah. Well, I mean, I requested time off. I work from home. Sometimes I go to the office.
Well, you better check it. Okay?
Okay.
I mean, we don't make mistakes like that. That was October 14th and 21st. I mean, I'm not really amused if somebody's doing it on purpose. I mean, I guess I gotta have a better sense of humor. But I can't imagine somebody paying $1. So you provide us with proof that you paid 100 and we'll adjust, but we don't make mistakes like that, all right? So you better take care of that real quick or you're gonna have another show cause pending.
Okay,
Good luck.
thank you.
All right. Is Mr. Baldwin here today?
Yes, he just walked out. Put some fun in.
Okay, because I'm in a sentence lately, Williams and Montesinos at the same time.
Okay.
So I hate to have you guys waiting in here.
You want to go grab?
No, I think just give him his time. You know, we got 3 co-defendants. I'm just gonna wait until he's ready to go. Okay,
Thank you.
thanks. You have something for me?
I do.
Okay, listen. I need to get those briefs. It's right in my desk.
Do you want me to bring it?
Here.
Okay.
Could I have Ryan Moore? Is Ryan Moore in here? No?
Morning.
Good morning. Just give me a second, guys. I'm gonna get a few of these other people out of here. Just bear with me. Or do you have to go, are you in another
I'm
courtroom?
just, Judge, I'm arranging for today, so just in case something else comes through, I was just trying to
I got,
ask to assist, so I figured.
I got it. Let me see what I can do.
We have 3 co-defendants.
I know you do, and I want to do them all at the same time, but I want to get a couple of these others out of here. 1 minute, Mr. Duncan, okay?
Thank you, Judge.
Thank you. All right. People against Ryan Jeffrey Moore, 25B148923. Good morning, Mr. Duncan, your appearance.
Yes, Your Honor, Murray Duncan appearing on behalf of the defendant Ryan Moore.
All right, so she's reducing this from improper lane use causing an accident to speeding 1 to 5 over. She says there's no injuries or minor damage. You're authorized to enter this plea on behalf of your client
Yes, Judge.
to the charge of 1 to 5 over, which, as you know, is 1 point. Responsible or not responsible?
He pleads responsible, Judge.
Actually, yeah. Okay, and that'll be 195, and I'm going to go ahead and give him until October 29th he can pay by?
Yes, Judge, that's fine.
Good enough. Have a good day. Thanks.
All right, Judge, thank you. Bye.
Trevor Bethea, 25B149593. Trevor Bethea.
On Zoom.
Okay, Mr. Bethea, come on up here, sir. Tell me your name. You have to start your video.
Give me 1 sec, y'all.
Yes,
All
sir.
right. Good morning, sir. Your name?
Trevor Bethea.
You met with the city attorney. You're going to plead to, or I should say the township attorney. You're going to plead his charge to commercial vehicle distracted driving. True?
Yes, sir. I plead guilty to it. I'm just asking for a couple of weeks to pay the fine.
Hang on, slow down. To that charge, do you plead responsible or not responsible?
I'm responsible.
I'll accept the plea 235. You need a couple of weeks. I'll give you until November the 5th. If you need more time, you call the court. We'll go on Zoom on or before that due date, and I'll be happy to give you an extension. Okay?
Yes, sir.
All right. Any questions?
No, sir, Your Honor.
Good luck. Thanks.
Thank you.
Priority Waste LLC, 25B149466. Good morning, Ms. Trombley. Your appearance?
Good morning, Your Honor. Elizabeth Trombley appearing on behalf of Priority Waste.
So we're gonna adjourn this. What do they need? Is there some issue?
No, they're Alex Dillon's cases, and he had a couple live hearings this morning, and I know he's been discussing them. He's doing his own work on them, so I'm just gonna let him handle them and adjourn them.
All right, we'll adjourn it to November 5th at 8:30, okay?
Thank
November
you so
5th
much.
at 8:30. Thank you. Have a good
you.
day.
You too.
Oh, wait a minute. Do we have another one with you? I also have Priority Waste LLC 25B149691B. So I don't know how that happened, but at any rate, that's a different file. And I have an A and a C file on this. So if you kind of ran out of here, Lisa, we're just going to make this one November 5th at 8:32, okay? All right.
Okay.
Got anything else down there?
Second, Judge.
I've got all kinds of things to fill up on this. You check and make sure that they're paid everything. Waste management. 25B149686 A, B, and C. Can you make sure they paid everything? Look on there, the waste management. All right, Mr. Powers, good morning, your appearance.
Good morning, Sean Powers, on behalf of Defendant Waste Management, Your Honor.
So we've got an exceeding gross vehicle weight on file B that is a misdemeanor. I've also got overweight and defective equipment files A and C respectively. For purposes of arraignment on the misdemeanor, does your client stand mute and waive formal reading?
Yes, Your Honor.
All right, so I'll enter a not guilty plea, and then I'm going to have, as I understand it, there's going to be a plea on file A. To overweight violation, there's going to be agreed upon fines and costs of $5,400. And once you plead to that then will be files C and V, that being defective equipment and exceeding gross vehicle weight respectively, will both be dismissed. True?
That's correct, Your Honor.
And you're authorized to enter this plea on behalf of the company?
Yes, I am, Your Honor.
To the charge of overweight, responsible or not responsible?
Responsible, Your Honor.
I'll accept the plea, $5,400, fines cost due by November 22nd. I'm going to also dismiss file B, exceeding gross vehicle weight, as well as file C, defective equipment.
Okay, thank you, Your Honor.
Have a good day. Thank you
You as
very
well.
much. Just give me 1 second, fellas, please, and I'll be right with you, okay? There's a lot of paperwork on these. if you plead guilty here, again, I'm going to say to impaired driving, the possible penalties are up to $300 in fines, 93 days jail, 360 hours community service, court costs are all those 4 points, license suspension or revocation in accordance with your record, and your vehicle could be or might have to be immobilized depending upon your record. Do you understand that? Did you sign an advice of rights? Did you read it and understand it? If you plead guilty, you'll be giving up all those rights and there will not be a trial. Do you understand that?
Yeah, sure.
And you understand if you plead to operating while impaired, the super drunk will be dismissed, but you're also, as part of this agreement, you've agreed to plead to PBT refusal, correct?
That's true.
All right. So you understand your rights.
Yes.
To the charge operating while impaired, how do you plead? To the charge refusal of the PBT, how do you plead? Responsible or not responsible? Were you operating a motor vehicle on Valley near Telegraph in Brownstown Township on September the 2nd and 25 at 2:41 in the morning?
Yes, sir.
Did you drink alcohol prior to that? And if so, what did you drink and how much?
Yeah. Yeah. I drink that for abilities, West Jefferson and Gibraltar. I had 5 or 6, white claws, beers, and several shots,
Shots of what?
tequila
More than 6?
shots.
Yes.
I don't believe so.
How many do you think you had?
Probably 5.
All right. Was your ability to operate that motor vehicle impaired due to the consumption of the alcohol?
Yes.
Why were you pulled over by the police?
Tree.
Single car accident?
Yeah.
Anybody in the vehicle with you?
No.
You think you crashed into the tree at least in part because of your alcohol consumption? I'm sorry?
Yes.
Counsel, this was a blood draw, right?
Yes.
And you stipulate that the results of the blood draw were 0.27 and that was accurate for purposes of this plea.
We do.
Are you on probation or parole?
No.
Anybody force you to plead guilty? Okay, I'm going to accept your plea. I find it to be an accurate plea made voluntarily and understandingly. I'm also accepting your plea to PBT refusal. I am going to go ahead and defer the sentence on that case, that is on the PBT refusal. I'm going to order screening and assessment on the impaired charge, dismiss the super drunk. We're going to give you a sentence date. Let me see your AA attendance, or have you shown it to your lawyer?
Do you mind if I grab my calendar really quick, Judge?
Sure.
There's a basically screen about it.
You've been gone, have you gone at least 4 times?
18.
I'm sorry?
18, sir.
You've gone 18?
He was doing them before the arraignment. Judge.
Okay.
That numbers.
Okay, and Lisa, what do you have for me for the sentence date here?
November 5th at 8:30.
Is that good with you?
It's not real good, Judge. They need to be in Monroe and then the why not later that day? Is the 12th or some other day?
Can we do the 12th? In other words, is Brownstown at least here in case I need him? I doubt I will. There's no restitution really.
It's your Woodhaven day, as long as you're okay with that.
Yeah, November 12th at 8:30.
Just to be transparent, Judge, Ms. Foleyhart did mention that she's waiting for estimates from the apartment complex.
Oh, well, then maybe we better set another date. How about the 19th?
19th at 8:30. Or they're here on the 20th as an overflow.
Either of those dates are fine.
November 19th at 8:30 will be your sentence date. Sir, keep doing what you're doing, and you are on the SoberLink, right?
Yes.
Okay, good enough. Thank you very much, sir. Go down the hall, get your notice, then go over to probation, fill out your questionnaire, and be interviewed. Thank you. All right, now I'm going to recall Gabriel Keith Montesinos, 25B149450, 25B149435A, LaShawn Williams, 25B149431, 25B149434A, Nathaniel Lately, 25B149362, 25B149241A. All right. Mr. Shemke, your appearance.
Good morning, Your Honor. Christopher Shemke appearing on behalf of my client. Mr. Williams.
Sorry, was the third.
Nice and loud.
Sorry, was the third.
Morning, Mass Gates, appearing on behalf of Mr. Lake, State of Florida. My name is Daniel Joseph. Attorney Mike Boland from the House Council P 65417. On behalf of Mr. Montesino, so to speak.
We are going to do two things. We're going to give them a review hearing date on both of these cases. Lisa, so 12 months out. And then we're going to set up a payment plan for each of them. And by the way, part of the sentence is restitution, if any, will be handled through civil litigation. Nobody showed up and made a claim. So restitution, if any, will be handled through civil litigation. Okay. So do you have a date for me on these?
October 7th of 26 at 9:00.
You said October 7th?
Yes.
October 7th, gentlemen, of 2026 at 9 a.m. will be your review hearing date. And if you are compliant, your charge will be dismissed. Both of these will on that date. Do you understand that, Mr. Williams?
Yes, sir.
Do you understand that, Mr. Montesinos? And do you understand that, Mr. Lately?
Yes.
All right, now. I'm simply going to have probation, I think. This case has taken enough time, these cases. You're going to go down the hall, get your notice. You're going to go meet with probation. And John, I want you to tell them probation to set up terms of payment on all of these for each one of these kids, okay? So probation will set up your terms of payment. And then I want you to know if you can't make the terms that they set up and you don't have the money, you call the court, we'll go on Zoom and we walk in here on or before a due date at 8:30 and I'll be more than happy to give you an extension, okay? Anything else, Mr. Shemke?
Your Honor, thank you, Judge.
Mr. Williams, anything else? Mr. Gaith?
Nothing
Mr.
else.
Shemke? I'm sorry, Mr. Baldwin.
Nothing else, Your Honor.
Mr. Montesinos, Mr. Lately. All right, guys, go down the hall, get your notices. Thank you. This has to go with those. Make sure you tell them probation to set up terms of payment. Are these guys ready on this case on Garrett? It says on Zoom. Is Matthew Garrett? Oh.
He's on Zoom.
He's on Zoom?
Yeah, he's Mr. Shemke's.
Do you have this one taken care of, Mr. Shemke?
I gotta move him. He went in a breakout room.
People against Matthew Garrett. 25W38289. Mr. Garrett, you're gonna have to take your hat off, sir.
Sorry.
Your name?
Matthew Garrett.
Why weren't you here on September 25th?
I live in West Virginia.
Yeah, I know, but you didn't show up on Zoom either. Why?
I didn't get, I know it's not a good excuse. I didn't get any of the papers sent to my sister's house in Rockwood, but she sent me a Snapchat of the recent paper I just got with this. That's why
Where's
I'm calling
Mr.
now.
Shemke? Mr. Shemke, I need you on this, please.
Good
Your
morning,
name?
Mr. Shemke.
What are we
Here on
doing
behalf
on
of
this
my-
guy? He hasn't paid his fines.
Yes, Judge, he's been out of state. He's apologetic. He wants to make a payment on Friday. And then in the
He's been out
circumstance,
of
Judge.
state since for 5 months, hasn't he?
Yes, Judge, in the circumstance, he'll admit to the violation and is humbly going to ask any leniency when asking for a payment plan.
Mr. Garrett, how much do you make?
I just got my job back. I make about $600 every 2 weeks.
What do you do there?
Subway.
How many hours you work?
I'm working 38 a week. I only
You
make 10
gotta
an
work,
hour.
you gotta work more.
Yeah, I'm trying to get a second job.
Well, yeah, you should be able to get a second job. I don't like this. You didn't pay anything on this. Nothing. And I told you should come talk to me, did I not? If you didn't have the money?
You did.
And you were supposed to pay $100 bi-weekly beginning June 9th, right?
I believe so, yes.
Yeah, okay. Well, this is the end of October. You paid nothing. What are you doing?
I just recently got my job back.
Why'd you lose your job? You fooling around?
No, sir. Actually, I dealing with magistrate court for a landlord tenant, and that's falling through with that. I'm just flopping around trying to get back. I've been trying to get back into housing situations, and I was kind of homeless for a while, so I got my job back.
Mr. Garrett,
Yes, sir.
you need to work harder,
Yes, sir.
right? Did you graduate? Did you graduate?
I have a GED.
All right. Well, you should be able to find better work. Nothing wrong
I'm a
with
felon.
Subway, but
No, I'm a felon, so it's hard.
how much can you pay today?
I can this Friday. I can pay 200. That's when I get my check.
You pay $200 by October the 24th.
Yes, sir.
Then $60 bi-weekly.
Yes, sir.
Beginning November 7th. November 10th, I'll make it.
Okay.
If you don't have the money, you call the court. We'll go on Zoom. Don't ignore me again, or I'm not going to be this nice. We understand one another?
Yes, sir, I do.
Show cause dismissed, Lisa. Thank you. Mr. Garrett.
Thank you. Yes, sir.
Grow up. Gotta grow up. Robert Thomas
sir.
Boyd, 25BA 2557. All right. Calling the prosecutor. How you doing, Mr. Boyd?
Hi, sir. How are you?
Not too bad. Your name?
Robert Thomas Boyd.
Are they going to give me good news when I call them out and they're going to tell me that you've done what I asked you to do? Or are they going to tell me, or are they going to tell me that you haven't done it all of what I asked you to do?
I got a big dump by the garage. I'm ready to go. I
Ready to go. What do you mean?
get my permit there tomorrow.
Mr. Boyd, you're not going to make me push in jail again, are you?
I hope not.
Well,
I
come
can't get
on.
it done from there.
Mr. Boyd. I can't wait to hear what they're going to tell. I've been waiting for bated breath since my recorder told me you were coming in here today. Yesterday, she told me that, oh boy, what has Mr. Boyd done? Or more importantly, what has he not done? Has he done anything? All right, I'll give you a lawyer if you want one. If you want a lawyer, I'm going to give you one right now. Do you want a lawyer?
No, thank you.
Your name.
Caitlin Foley Carter from Fresno Township.
Your name.
Rocker someday up prompt time.
What are you going to tell me? Tell me it's all cleaned up. Tell me it looks like the Taj Mahal. Tell me we'd all want to move in there.
The only progress is that he's gotten a dumpster this week delivered to the site. On the side of the dumpster that I committed, the garage is still.
Oh, Mr. Boyd, you're killing me. You're killing me.
I was waiting till I come in today before putting anything in the dumpster. But
Why?
if you send me to jail for 85 days, I'm gonna send the dumpster back. I can't have it sit there.
Why are you being a wise guy with me?
I'm not, sir. I'm just telling you the truth.
I don't know what to do with it. Short of sending him for 85 days. He's going to be in there for Christmas. How old are you again?
Pardon?
How old are you again?
78, the 27th of this month.
Well, we share a birthday. Just, you have a couple years on.
Yes, sir.
What am I going to do?
Your Honor, I don't know what to do. We did have an opportunity this morning to speak to Mr. Boyd. He told us just about the same, that he hasn't done a whole lot since last time we were here. He hasn't obtained a demolition permit to take down that garage, so
He has or hasn't?
so he made no progress towards doing at least that very first goal. I do have a picture that Mr. Harris took yesterday showing the front of the property that still has the trailer, the boat, the vehicles, what have you.
I don't know why you're making me do this. I don't know why you're making me do this, Mr. Boyd.
I put the boat out in front.
Mr. Boyd, I don't know why you're making me do this. I do not know why you are pushing me to the point that you leave me no choice. I don't understand why you're doing this. I really don't understand it.
I do work slow. I'm 78,
You haven't done anything.
I have. I've done a lot. I've moved a lot of stuff. I had to throw away what I didn't want.
What did you move? What did you move? When did you move it? I don't know that you've done anything.
You wouldn't see it because I put it away.
Can you guys give me something positive here?
Try to start with the positive that he got the dumpster. He has not, nothing that the boat studies for sale, there's not a for sale sign on it. I mean, at least put a for sale sign on it if you're gonna park it in front of yours. Because he's moved the boat when you were there, it was in the back.
Right.
He moved it to the street.
Nice.
Makes it look worse, but he says it's for sale, but there's not even a for sale sign on it.
How's somebody supposed to be a mind reader? See a boat out there and they think it's for sale without a sign? Don't have anything to be for sale if there's not a for sale sign.
My son promised me that he was gonna put a sign on it. He's half owner in the boat.
I don't know what to do. Do you have any ordinance that allows you guys to go in there and clean it up and put it on his tax rolls?
Short of abating the nuisance civil court, we don't have that.
Short of a what?
Abate the nuisance civil act.
In circuit court. I know, but maybe that's the route you need to go.
I was hopeful that this would have put Mr. Boyd on notice, and I understand that doing some time maybe would have jump-started the progress, but unfortunately.
I don't know what,
Give me a chance to start tearing it down.
I don't know, Mr. Boyd,
Got a
Come on.
nice big dump box in.
how long's it been going on, this case, Miss Foley Carter?
Based on the register of actions, he's had ordinance violations dating back to 2011.
2011, we were young then. You were young, I was young.
This citation was issued back.
It's 14 years ago. Go ahead, I'm sorry.
Sorry, Judge. This citation was issued back in April. Prior to that, he had the civil infraction citation for the same thing.
So you've done nothing. You've done nothing. When were you last in court? Mr. Boyd, I feel horrible. You are a pleasant, likable man. But you are not complying with the orders. That's a dangerous building.
Yes, sir.
Forget the blight. It's just flat out dangerous over there. And I can't get you to do anything. I usually would like to think I'm more successful at causing people to understand that they have to do something, and I don't know what to do with you. I really don't. I don't know what I can do. When were you last here? A month ago?
Something like that.
And you've done nothing but move the boat out without a for sale sign and order a dumpster that has nothing in it.
Well, my truck was in the shop for 3 weeks.
Well, good. Then if your truck was in the shop, then you had to be home and you had all kinds of time to do things. I don't know what else to do, guys. I just don't know what else to do. If I saw some effort.
Well, I'll see how well I do with the dump.
New review hearing date in 4 weeks, Lisa.
November 19th at 8:30.
November 19th at 8:30. When I go home tonight, I'm going to feel horrible. But I have to give you another 5 days. I'm setting another review hearing date on November 19th at 8:30.
That doesn't give.
Mr. Boyd. It's just this the way it's gonna go until you take care of the property. You think I feel good about this? I'm not gonna argue with you.
Yeah.
I'm not gonna argue with you. You're just defiant. I don't know what is going on with you, but I can't allow this to go on. I just can't. This is nothing I want to do. Zero interest in doing what I'm doing right now. None. I'll go home and think about this tonight. Like, what could I have said to Mr. Boyd on the multiple other occasions that he appeared in front of me that might have compelled him to do something?
I feel I have done things.
Mr. Boyd? I'm sorry. Have a seat. I feel horrible. You make me do things I don't want to do. Have a seat over there, sir. Derek Paul Lopez Jr. 25B149536. A and B.
Good morning, Your Honor. Thank you. Good morning, Your Honor. For the record, House Counsel, Attorney Mike Baldwin, so please state your full legal name.
Derek Paul Lopez.
Judge, thank you very much. Judge, he's been arraigned.
I don't think I arraigned him. I think he asked for a lawyer, so
I'm going to ask that the court allow him an opportunity to fill out the form. We're asking for discovery. I've already.
Yeah, but does he stand me wait for him reading?
I apologize. I thought he was already arraigned.
No, we did not arraign him. Nope, not out. Is that what he's doing?
He is.
Not guilty, pleas entered. He actually has 4 files. He has 536 A, B, and C, and 25B149537. 2 of those are civil infractions. 2 are misdemeanors. Not guilty, pleas are entered on the misdemeanors. $500 personal bond on file 536A, which will be incorporated with the rest. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Lisa, what do you have for me for a date?
Lisa, can you make sure that it's scheduled when I'm here? I'd like to handle the file at the time.
November 5th at 10:30.
Okay, sir, and you fill out a petition for a court-appointed lawyer. We're going to give you one now. And then after you do that, you go down the home, grab your notice, and you're all set.
I gave that up. I'm in Florida on the 5th. Somebody's going to be handling that. Would you like me to continue on with the file? I'm going to be reviewing the discovery. Can we have a different day?
Yeah, I'll give you the 19th.
19th, please.
19th at 8:30.
Thank you.
Okay, so hand the petition there, will you please? Fill that out, sir, and then go down and get your notice. Good luck.
Okay.
People against. Hall, Terrence Arnold Hall, 25T646123. Good morning, your name? Your name?
Terrence Arnold.
Okay, so you really have to take that hat off, okay? Hat. Oh. Okay. You met with the prosecutor and you are going to plead, well, wait a minute, we've already taken that. Needs new payment plan. How much have you paid on this?
$75.
Okay, what kind of a plan do you need, sir?
Next week.
You paying $75 a week starting next Friday?
Well, pretty much I need bi-weekly.
75 bi-weekly beginning when?
Next week.
I'll make it November 3rd, okay?
Sounds good.
A week from Monday, November 3rd, and then if you need more time, no problem. Come talk to me. I'll be glad to give you an extension, okay?
Okay, thank you.
Thank you. Thomas. Naya Lene Thomas, 25B148943, A and B. Where's Naya Thomas? Is Naya Thomas out here somewhere on Zoom?
No, she has not been on Zoom.
Oh, I see. Defendant contacted a prosecutor requesting an adjournment as she's unable to appear. Prosecutor encouraged her to appear, but advised the prosecutor will request the matter be adjourned at her request, but it's in the court's discretion. I'll give her an adjournment to what, the 5th?
It's November 5th at 10:30.
I don't know why she can't appear, but she's gonna have to. So did we say about in person on her notice? Yeah, we did say in person. I'm gonna go ahead and adjourn this. And we'll continue the in person. People against Daly. Deborah Jan Daly, 25B149-488A and B. Could I have Sean Ray seated at the table? My right, your left, Sean Ray. Come on up to the podium, Ms. Daly, your name? Charged with driving on a suspended and disobey a traffic signal, you have the right to a lawyer. Do you want one?
I don't think so.
I'm sorry? You sure?
No.
Well, then get one. Go out in the hall, we'll give you a lawyer, all right? You can go right out in the hall and he'll set you up. Good luck. Sean Nicholas Ray, 25B144-497B. Come on up to the podium, sir. Your name?
Sean, all right.
It says you're compliant. Raise your right hand. You solemnly swear affirm under penalties of perjury the testimony you'll give in these proceedings with the whole truth self you got. Okay, nice and loud for me. On March 13th, I placed you on probation. You've applied for early discharge. The case was taken under section 771.1. Since I placed you on probation, again back on March 13 of 25, have you been arrested?
No, sir.
Any new charges?
No.
All right, so I sent this to the prosecutor, or we did. They're going to go ahead, even though the agreement was, at least I placed you on probation for 12 months. They're going to go ahead and agree to early discharge and to dismiss the case under 771.1 since there has been compliance. I wish you well. Case dismissed. You're all set. Good luck.
Thank you, sir.
Catella, Gregory Adam Catella, 24B147-015B. Do you have geez, I'm sorry for you too. You've been sitting here all morning. My apologies. Your name?
Gregory Adams, Judge.
Raise your right hand. Solemnly swear affirm the penalties of perjury. The testimony you've given these proceedings will be the whole truth self you got. All right, just give me 1 second if you will. Did I not give him a review hearing date, Lisa?
I'm sorry, Judge, which case is this?
This is Catella, Kutella.
Yeah, today's a prosecutor review.
I didn't write it on the thing. Okay, good enough. No objection, early discharge and moves to dismiss. Raise your right hand. You solemnly swear affirmative penalties of perjury. The testimony you're giving these proceedings will be the whole true self you got. All right, since you were in court and I sent you on February the 5th of 25, have you been arrested? Have you had any new charges filed against you? No other cases pending?
No.
All right, you're compliant. Congratulations. Case is dismissed. Motion to the prosecutor. We'll send it out. Sorry you had to wait so long. Good luck.
Okay, good.
You too. Thanks. All right. Pernicano. Paul James Pernicano, 25B82401C. Pernicano, your name?
Paul James, Pernicano.
All right, so this was taken under 771.1. I'm going to ask you to raise your right hand. Solemnly swear affirm the penalties of perjury that the testimony you're giving these proceedings will be the whole true self you got.
I do.
Since you were in court on March 26th, have you been arrested?
No, sir.
Any new charges? So you are here for a review date, or no, actually you applied for early discharge. Prosecutors looked at everything. She says you're compliant and she moves to dismiss. Congratulations, your case is dismissed. Wish you well, Mr. Bertano. People against Raisingani. Marion Raisingani.
4000. Present before the court is Mr. Banks. Oh, there he is. Present before the court is Mr. Banks, and we have Mr. Harrison, the prosecutor's office, Officer Evans from probation. We're here today, Mr. Banks, because I've received a report that alleges that you have violated the terms of your supervision. The allegation is that you tested positive for meth on October the 9th and that you were non-compliant with recovery defined. You have the right to be represented by a lawyer in these proceedings, and if you can't afford one, I will appoint a lawyer for you. You want to be represented by a lawyer?
Yes, sir.
I think I'd previously appointed Ms. Hinkle to represent you. Any reason I shouldn't appoint her again?
No, I like her.
All right, Mr. Kuroko has an affidavit that tells me in writing that you don't have the funds to hire a lawyer and want one appointed. Mr. Harris, anything from the state?
Not at this time, Your Honor.
Your Honor, before I leave, I'm just gonna.
Yeah, let's get the lawyer stuff out of the way first. I do find that you're indigent for the purposes of hiring a lawyer. I'm going to appoint Ms. Hinkle to represent you. You have her contact information there. We're also going to send her an email today that lets her know that she's been appointed, and I'm going to set this case for a final hearing. It'll be in about a week to 10 days. What do you want to tell me today, if anything?
All right, Your Honor, so I already know what's going to happen. We both already know what's going to happen. I know you're going to send me back to prison. I just want to let you know that I don't want you to think that I didn't try, Your Honor. When I called Recovery Defined, they told me that they was going to be, the address that I was going to was a different, well, I did not know, okay, where they sent me was where my drug addiction first started, Your Honor, and it, going back to that same area, and that, like a block over from where my life flipped completely upside down, was unexpected. It was, I'm sorry that I messed up. I tried. I should have talked to Hillary more. I didn't know that if there was a possibility of relocating sober living was a possibility. I had no clue that they was going to put me in that, neighborhood. If I'd have known, I would have never went to that place, Your Honor. I would have never went to that place. Like I said, I couldn't go to group. I couldn't do nothing. And that's the only thing that, like I said, like, I'm just letting you know that I did try, Your Honor, and I apologize. Like, I wanted to do nothing but make Miss Evans happy, succeed in this. I just wanted to let you know that it wasn't that I didn't try, and I'm not trying to not really disobey or whatever. You get what I'm saying? Like, I just wanted to let you know that if I'd have known it'd have been that neighborhood, Your Honor, I would have never went to that, like, it was so much. I apologize. That I just don't want you to think that I didn't just go out there and say, screw Oda or nothing like that. Like, it wasn't nothing about like that. Like, I really did try, Your Honor, and I got to see my daughter get married. I was trying to get back in my son's life. Everything was going decent, and it was so much pressure. I thought, I'm be honest with you. I just wanted you to know before I went back and before you sent me to prison, and that.
Well, I'm not sending you to prison today, Mr. Banks. We still have a final hearing, although your general sense of it seems likely. But I don't know. We're going to talk about it at the next hearing. I do find there's probable cause to believe you have violated the terms of your community control. I'm going to hold you in jail until the final hearing. I'll see you in a couple of weeks.
Yes, sir.
Next is the case of the State of Ohio versus Brandy Orman. This is case number 2209. Present before the court is Ms. Orman, right? We have Mr. Harrison, the prosecutor's office, and Officer Evans from probation. We're here today, Ms. Orman, because I've received a report that alleges you have violated the terms of your ILC. The allegation is that you were unsuccessfully terminated from women's recovery, maybe for not the most serious of issues. Let's see, then there was another part of that too, though, right, Officer Evans? It was more than getting kicked out of women's, right?
There were some issues with, aside from her behavior, just with failure to progress with the treatment portion of it. And then she had previously had a technical sanction for a relapse.
No, I mean, there's a second part of the violation. The violation is getting kicked out of women's and what else?
And then just they not progressing with treatment.
Okay. I don't really know what to do about this case, Ms. Orman. And I think also Officer Evans said that you're not really decided on how you want to handle this either. So my plan is to set this for a final hearing, probably in about a week to 10 days. so that we can figure out what to do. You have the right to be represented by a lawyer at that hearing, and if you can't afford one, I will appoint a lawyer for you. Do you want to be represented by a lawyer?
Yeah, I do kind of.
All right. I previously appointed Mr. Oswald to represent you. Any reason that I shouldn't appoint him again?
I don't even think I've ever seen him, maybe briefly.
Okay, so do you?
So if I can't get it together by then what? Should I just do it now? Or?
What's the recommendation of Probation Officer Evans?
Your Honor, at this time, we would be looking for a higher level of care than the residential treatment, which would be something like a CBCF. However, I understand that there are some health issues going on that we would need to resolve before then.
I think it makes sense to do a referral for both a community-based corrections facility to see if we can even get her in with her medical issues and explore the other options. I'm going to set it for a final. Do you want to be represented by a lawyer at the final hearing?
Just a court appointment, I guess.
All right. Do you not want Mr. Oswald? You want somebody
Yes.
different?
That's fine. Court appointed.
You didn't hire Mr. Oswald the first time, did you?
No,
Do you want me to appoint him or somebody else?
I don't know who else, but anybody's fine.
Okay. Who will be appointing, Ms. Kuroko? All right. Ms. Kuroko has an affidavit that tells me in writing that you don't have funds to hire a lawyer and want one appointed. I do find that you're indigent for the purposes of hiring a lawyer in the case. I'm going to appoint Mr. Oswald to represent you. You have his contact information there. We're also going to send him an email today that lets him know that he's been appointed. We're going to make some referrals, do some updated assessments, and see where we're headed. Is there anything you want to tell me today?
Well, you know, I've been doing really, really good. I do like going to treatment, and I was doing really well. And then my birthday came, and I did fall off for like a day, and then I came back a week later and turned myself into women's, you know, and I got in a hold of Hillary. And I went back, and then I've been so sick that I haven't been able to, like, technically eat the food that they've had there. So it was just a big thing about.
When's your next doctor visit? When's your next doctor visit?
The 3rd.
Okay.
Yeah. And it's gonna cost me like $250 if I don't go. You know?
All right. No, I mean, I think it's important that we get that taken care of, so we'll work out a furlough for that, but we'll be back here, I would imagine, before then. So let's go ahead and appoint a lawyer for you. I do find there's probable cause to believe you have violated the terms of your supervision. I'm going to hold you in jail until the final. I'll see you in a week or so. You can head out that way. All right, next is the State of Ohio versus Christopher Haggerty, case number 23 CR 40763. Present before the court is Mr. Haggerty, right? And we have Mr. Harris from the prosecutor's office and Officer Evans from probation. We're here today, Mr. Haggerty, because I have received a report that alleges you have violated the terms of your supervision. The allegation is that you absconded back in November of 24 and you refused a drug test when you were arrested. We also have a number of other violations of probation which are less significant than that. You have the right to be represented by a lawyer in the case. If you can't afford one, I will appoint a lawyer for you. Do you want to be represented by a lawyer?
I don't think there's no need for that.
I mean, the recommendation is that I send you back to prison.
Yeah, I will. That's probably, I just want to get it over with. I mean, I appreciate the chance and opportunity, and I just couldn't get the ball all the way down the court, fumbled it. So we're just ready to finish it, get it over with, get off probation, and get my life back.
All right, Ms. Kuroko has a waiver that tells me in writing that you don't want to be represented by an attorney. Mr. Harris, anything from the state?
Your Honor, we are in agreement. The defendant was given an opportunity on community control again. Once his release, he's failed on several different levels. We don't see that he would be amenable to community control now.
I'm going to accept your waiver of counsel. Do you admit or do you deny that you violated probation?
I admit.
Based upon your admission, I find you have violated the terms of your supervision. We have 297 days of jail time credit, 168 days of prison time credits. That's about 15 months in. Anything else you want to tell me?
That's it.
All right, court finds that you have violated the terms of your supervision and that you are not amenable to community supervision. I'm going to order that the 36 months, which was 24 plus 6, be imposed. And I will give you credit for the jail days that you've done. The Department of Rehabilitation and Corrections, they calculate their own prison days, but we do an entry so we make sure that we don't go over that amount. Good luck to you.
Okay, thank you.
Next is the case Armin Fishburne, case number 24 CR 41714. Present before the court is Ms. Fishburne. Great.
Yes,
We have Mr. Harris in the prosecutor's office, Officer Kell from probation. We're here today, Ms. Fishburne, because I have received a report that alleges you have violated the terms of your ILC. The allegation is that you used meth on October the 17th, and you got kicked out of Recovery Works. Officer Kell and I really don't know what even to recommend at this point. I think what we're going to do is set this over for a final. I don't know about Recovery Works again. I think you need probably partial hospitalization level of care, but I don't even know if Recovery Works will take you back. So that's a long way of saying I'm going to set this for a final hearing in a couple of weeks so that we will have all of our options available to us. Do you want to be represented by a lawyer at that hearing?
No, thank you, Your Honor.
All right, Ms. Carrillo has a waiver that tells me in writing that you don't want to be represented by a lawyer. Do you admit or do you deny that you violated the terms of your supervision?
I admit, Your Honor.
Based upon your admission, I find you have violated the terms of your ILC. Like I said, we're going to set this for a hearing to see if we can even get you back into Recovery Works, and maybe that's not such a great idea. I think that's what you want, right?
Yes. May I say something?
Sure.
Okay, so, I was at Recovery Works, and I was doing great. I had no issues. There's a situation where, somebody in the program was, using in front of me every day. And one day I had happened to take a walk, and next to our house was a gas station. And I walked in there, and I ended up buying a joint from the gas station, and I smoked a joint. So the next day I went and told on myself, and I gave them a urine. I'm like, hey, I messed up. I explained to them the situation. They let me stay for about a week after that. Had no more issues. Like I said, I was going to every class. I was on the ankle monitor. I had no issues whatsoever. And then one day after group, they told me, they were like, we're going to discharge you because you have a dirty urine. And I was like, oh, wow, that sucks. Okay. So my first instinct, because I tried to call my PO, but I guess she was out of the office and unanswered. So, my first instinct, I went straight to DeCoach in Dayton. And DeCoach in Dayton, you know, they really liked me. They were like, of course you can come here. But then I told them I only had pot in my system. So they said, we can't really accept you just with weed in your system. You have to have something heavier. And I was like, so you're telling me I have to use to get into rehab? And their words exactly, we can't tell you to use, but you do have to have drugs in your system. So I ended up smoking just to get in rehab. I did get myself into a rehab because I went to the DeCoach in Dayton, the DeCoach in Cincinnati, and the DeCoach in Fairborn. So all in that, I think all in a 24-hour period, I finally got myself into rehab. And then I called my PO and I said, I relapsed, but I got myself into rehab. And she said, just hang on there, we're coming to get you. I knew I was going to jail. I did not cut off my ankle monitor, and I continued to go to class my last 20 minutes of freedom because I wanted to do the right thing. And I want to apologize because in that moment in time, I was just trying not to go to jail. I relapsed because my train of thought was if I relapse, then I'll be in recovery, and then they won't send me to jail because I'm in, you know what I mean? Very bad train of thought. Me and my probation have talked about that. I should have called and asked for help before I tried to make bad decisions on my own. But I just want to point out that It was bad logic, but I have no desire to do drugs. I felt dirty after I did drugs, and I did not do it a second or a third or a fourth time. I just did it one time to get it in my system so I could go to decoach. I never cut my ankle monitor off, and I did make bad decisions, but Your Honor, I think I am one of the clients who actually try my best. You know what I'm saying? I did not, you know what I mean? If I did not want recovery, if I did not want to succeed, I would have cut my box off when she told me she was coming. I would, you know what I mean? I would have done all the wrong things, but my last 20 minutes of freedom, I actually proceeded to go to my drug and alcohol class and wait for my probation officer to come and get me. With that being said, I really liked Recovery Works. I was getting stuff done. All I had to do was get a birth certificate. I got my ID and I was going to start working, and life was really good up until I smoked that one joint, and it was actually the best it's been in a long time. So
that's a lot to take in, Ms. Fishburne. Some of it I get seems reasonable. Some of it seems like a lot of nonsense to me. But the bottom line in all of this, Ms. Fishburne, is that we generally don't give up on people who don't give up on themselves. So I do want to try to get a path forward in some sort of recovery. I just don't know what the best kind of recovery is. I don't want to keep doing the same thing we've been doing over and over again, expect a different result. That doesn't make a whole pile of sense. But also, I think we have some things to explore. So I do find there's probable cause to believe you have violated the terms of your supervision. I'm going to hold you in jail until the next hearing, and we're going to figure out what our options are at the next hearing. And you and I and Officer Kell will pick what we believe to be the best option moving forward. Okay?
Thank you.
All right, that's all. Next is the case of the State of Ohio versus Samuel Zawowski, case number 23 CR 40824 and 24 CR 42225. Present before the court is Mr. Zawowski. We have Ms. Trelevin from the AG's office, and also Mr. Harris, who might be kind enough to do the paperwork today.
Yeah, I can help.
And we have Officer West from probation. We're here today, Mr. Zawowski, because I have received a report that alleges you have violated the terms of your supervision. The allegation is you left the state without permission, you didn't report a change of address, and you were engaged in gambling, all of which are a violation of your probation. You have the right to be represented by a lawyer in the case. If you can't afford one, I will appoint a lawyer for you. You want to be represented by a lawyer, right?
Yes, sir.
You're going to hire one, or you want one appointed?
All my family's up north, so I don't. It's been hard to get a hold of anyone from the jail, so I mean, I guess appoint one for now. I don't.
I think I'd previously appointed Mr. Williams to represent you. Any reason I shouldn't appoint him again?
No, sir.
No, you're okay with Mr. Williams?
Yes, sir.
All right, Ms. Kuroko has an affidavit that tells me in writing that you don't have the money to hire a lawyer. Mr. Harris, Mr. Trelevin, do we know if we have any victims present? Any victims present on Zawowski
I
case?
emailed them yesterday, but I don't believe they were coming.
Okay. All right, I do find you're indigent for the purposes of hiring a lawyer in the case, and I'm going to appoint Mr. Williams to represent you. You have his contact information there. We're also going to send him an email today that lets him know that he's been appointed. So we have Ms. Trelevin on the felonies. Anything that you want to tell me about this today?
No, Judge.
Mr. Harris, you're on the misdemeanor. Anything I need to know about the misdemeanor?
No, Your Honor.
All right. Mr. Zawowski, what do you want to tell me?
I never left the state, Your Honor, and that's easily provable, very easily provable. I've made all my payments on my fines. I've isolated myself. I stayed in myself. I will work. I've not left the state. All I do is take care of my dogs, trying to see my kids when I can, be a good dad. I wasn't trying to disrespect you or the court or Miss West or nobody. Really, I've tried. I mean, I've made My payments are like $575 a month. Most months I'm making $1,000, $700, $800 payments. I've been going above and beyond. Miss West knows that I have a settlement coming through that will pay my fines in full by November through my previous employment with Miller Industries. All I want to do is resolve this, get the victims paid in full, and move on with my life. I'm not trying to disrespect.
When's the settlement happening?
In November.
November when?
I sent the email to Miss West. I'm literally waiting to sign and receive the check.
All right. I do find there's probable cause to believe that you have violated the terms of your community control, and I'm going to set this for a final hearing. I anticipate that this will be a contested hearing, so it probably makes sense to set it for maybe a half hour, 45 minutes, and get with Mr. Williams, and we'll see everybody back here for the final. Anything else?
Just for clarification, I saw on the docket the 24 case is on the docket, but the 23 is not. If I'm reading that correctly, I show one case number on it.
23 is on the docket. At least it's on the one I have. 2 up from the bottom of the first, 3 up from the bottom on the first page.
Okay. All right, they separated them out. I see.
Yeah, when they're
Okay,
all at the same
bottom.
time, then it sorts them by case number.
Okay.
Very annoying.
All right.
Okay? All right, we'll see you at the next hearing.
Thank you.
All right, next is the case of the State of Ohio versus Ryan Battles, case number 22 CR 39623. We are here today for an early termination hearing. Is there anyone here on the Battles case? All right, I am going to grant early termination of supervision in Mr. Battles' case. Next is the case versus Dale Lovelace, case number 24 CR 41365. We're here today for an early termination hearing. Is there anybody here on the Lovelace case?
Your Honor, the defendant is here.
Oh, Mr. Lovelace is here. All right. We have the report from probation indicating that Mr. Lovelace placed on 3 years community control in August. And it looks like he has been negative for all substance, remained compliant. No issues, no court orders that have not been satisfied. The recommendation is for early termination. Is there anybody else on the Lovelace case? No? All right. What do you want to tell me, Mr. Lovelace?
Well, I think over the past year, I've had some tough times, but I've learned to get through them. I think the mental health therapy I've had is working decently. I do apologize again to the courts for the problems caused that day. I can't see it ever happening again.
Officer Tork, anything else on this?
Nothing further.
Mr. Harris?
Your Honor, the only thing that in looking at the case, he's been on for a little over a year. He was put on for 3. This was an assault. It looks like there's some mental health component to this as well, so there is a concern by the state. He is doing well under supervision. It just seems like at this point it's only a third of the time that he was placed on as far as that is concerned. I did see also that he wanted to go back to the place where this had occurred. It was denied by the court. He's been trespassed from the hospital as well. So there is still concern by the state as far as releasing him this early.
Well, it looks like everything is going as well as can be expected, Mr. Lovelace, so I am going to go ahead and grant your early termination of probation. Officer Torek, it might make sense to consider Mr. Lovelace for Officer Martinez's Forge program. I don't know if there's any interest in that, either by you or by him. So you might take a minute after the hearing, if you have some time, to talk to Mr. Lovelace about that. Is there any interest in that, you think?
I would have to speak with Mr. Lovelace. During his time on supervision, a point of interest was his
interactions with law enforcement. I've worked with him to try to encourage more positive interactions. Throughout the time, I actually had the opportunity to meet him at Franklin's National Night Out while there were a lot of law enforcement present. I would have to speak with him about how he would feel about being back in front of the victim in the case and evaluate that further. But ultimately, if that's something he wishes to proceed with, I can keep in contact with you about that.
We have this program, Mr. Lovelace, we call it the Forge program. Might stand for something, I don't remember if it does or not, but it's a program where at the end of somebody's probation, after they're off of probation, we do, in a controlled setting, bring you, the victim of your case, together with the probation officer and some other folks, have a little chat about how things have impacted you and them. It's been going pretty well so far. We've done it about 3 times. You're off probation with me, so you don't have to do anything that you don't want to. I think we do that on purpose because I don't want this to be like, oh, if I say the right things or do the right things, I might get off probation early. That's not the purpose for this program. The purpose for this program is for you to have the opportunity to meet with your victim many years later and have the victim have the opportunity to meet with you, maybe see how sometimes probation can be a good thing. It may not make sense in this case, but if you want to talk about it with Officer Torek, you can. All right, good luck to you.
Appreciate it, Your Honor.
All right.
Thank you.
I am going to grant the early termination.
F99, State of Wisconsin versus Robert English. The state appears through District Attorney Kevin Schmidt in person. We have Daniel Chapman, Defense Counsel in person with Mr. English in custody. We're set today in this matter for a sentencing hearing after revocation. Mr. English pled guilty to receiving stolen property greater than $10,000, a Class G felony. He was put onto probation in which he was given certain conditions to follow, 2 years of probation with a withheld sentence. He has been revoked off of probation and he is currently now in front of the court for sentencing after revocation. The court has received and reviewed the Wisconsin Department of Corrections revocation packet and warrant and order request. I did not find anything from my perspective that jumped out to me as any type of material mistake for correction. The court also received as part of that packet the decision from the ALJ, the administrative law judge, in his revocation. Are we in victims' rights compliance?
Yes, Your Honor.
All right, thank you. Mr. Schmidt, argument and sentencing recommendation, please.
Before that, I did receive the packet. I reviewed it. I don't know if this is a correction, but page 2 of the DOC packet indicates where the dates they recommend to use for calculating jail credit. If you use those, you'll get 242 dates. Pages 28 through 29, however, list additional dates that also should be attributed that aren't in page 2. If you use those, the credit should be 262. So I agree with Mr. Chapman. It should be 262 if we include pages 28 and 29.
All right. Okay.
And that was the confusion where we were figuring that out before court.
All right. Thank you. And so, Mr. Chapman, you agree with the 262?
Yes, specifically page 29, I think, was not included in the
revocation order and warrant from the Division of Hearings and Appeals.
Okay, and you also confirmed with the either captain or lieutenant of the jail with regards to how many days he has since the packet or their calculation?
I did not. I know he's been in jail since May 27th of this year. My inclusion of, or my calculation of 262 days goes up until today.
Okay. All right, Mr. Schmidt, argument and sentencing recommendation, please.
Thank you. Robert English was originally convicted in this case of receiving stolen property. The criminal complaint details that police found property burglarized from nearby places at his residence with his mother in Danbury. The implication in that case was that Kenneth Ochterling was somehow involved in the burglaries and he was just receiving property he believed was stolen. This is a felony with a maximum penalty of 5 in, 5 out. His only other conviction in Wisconsin is a disorderly conduct in 2022. Minnesota seems to be where most of his convictions are, where most of his life has been. That's where I'm assuming that because that's where the bulk of his criminal history is. He does have multiple convictions there, a felony and misdemeanor for generally either possessing drugs or for lying to the police. He's been extradited from Wisconsin to Minnesota 5 times for either not coming to court in Minnesota or for probation violation warrants. In this case, about a year after being placed on probation, he absconded from probation and once again came in possession of stolen property at his mother's residence in Danbury. He did the exact same thing that the court placed him on probation for a year prior. Both cases are victim cases. Both hurt Burnett County itself. In this case, you could tell from the whole packet, because they send a lot more information now than they used to, that he admitted to the violation of the burglary in Minnesota. He contested other violations in Wisconsin. The ALJ ultimately decided they would only find that with whatever evidence was presented at that hearing, receiving stolen property, again, not burglary violations here in Wisconsin. If you're wondering why he likely admitted for the Minnesota one, that involved DNA evidence being found at the scene, so that made it a little different than the Wisconsin ones. The balance sheet shows that for the year he was on probation before absconding, it didn't appear he paid any restitution towards Department of Corrections. Therefore, the victim in 23 CF 99 will have the burden after today to collect on a civil judgment.
And what was that amount? Oh, I have it right here. I believe it was $930.
Yes, if you scroll to the last page of the DOC packet, it was $930 for restitution. If you add in all the other costs, it's $1,541. And that's where I made the determination that nothing had been paid on it. Yeah. So at a probation revocation hearing such as this one, the court's supposed to do the sentence it would have done back at the time Mr. English was originally sentenced. However, it can also consider his behavior on probation that can modify what the sentence can do. So in other words, conduct on probation could result in a worse sentence based upon how probation went. Robert English is 40 years old, meaning he doesn't have a young developing brain, but he's also not in the age range where we'd say they're, aging out of crime. His history actually shows like a ratcheting up of crime as he's entered middle age. He has a past history of crimes. However, they're just drugs and lying to the police. They are not really for stealing. This was his first conviction for something like that. So this is obviously not a max 5 in, 5 out sentence. He doesn't have a history of criminal convictions related to stealing that would, I think, be necessary to justify that kind of sentence. DOC recommends a 1-year jail sentence, which he's like I'm bad at math, less than 2 weeks away from a time served sentence on. I don't think this is a 1-year jail sentence. I do think that if Mr. Robert came before the court in 2023 at the original sentencing and said, I don't want to do probation, I don't think I can do it, I think there's a chance the court might have done something like a 1-year probation sentence. I suspect the court might have required upfront restitution for that, but I don't know for certain. But instead, Mr. English convinced the court to give him a chance. And the court took a chance when it placed him on probation. It even gave him the ability to discharge early from probation if he paid the restitution off and had no violations, which I took to mean from the original sentence. The court, probably because of the lack of history of theft convictions, gave Mr. English a chance, wanted to believe in him that he'd want to make things whole, make amends. I think for that reason, the fact that Mr. English did not pay back restitution, he stopped reporting to probation. DOC, the way ALJs used to handle abscondings, they used to say that strikes to the heart of probation. You can't be on probation if you're not being monitored. You're just not getting punished then. And because according to the sentence after revocation packet, with the admission of the burglary in Minnesota, that's an escalation. And with the finding of the receiving stolen property is one of the other violations they found. And just the fact pattern. He got placed on probation for receiving stolen property, having stolen property at his mother's house in Danbury involved with Kenneth Ochterling. And the violations are the exact same behavior. It's really bad when a person placed on probation while they were supposed to be on probation absconds and then does the same thing. That, I think, escalates it beyond the 1-year sentence. It's still not, a max prison sentence. I do think that some prison is necessary here because of how bad probation went in this case. With the information of the progression of probation, I would recommend something more than 1 year county jail. I would recommend a half sentence of 5 years where the breakup would be 2 years initial confinement, 3 years extended supervision. So that would still be half the total exposure. And then it'd be weighted toward the ES, meaning he's doing less than half of the initial confinement he could do and a little more than half of the ES. Well, I mean, the court can do a lot more ES. I think that sentence is necessarily to not depreciate the seriousness of the offense and also the behavior on probation. I also think that such a sentence is necessary because it'd be a terrible message in terms of specific deterrence and general deterrence to the public. If a person can, look at probation as just like a gamble. If I don't get caught and keep trucking forward with the same criminal behavior, then maybe I'll just avoid a jail sentence at all. And that shouldn't be how probation should be viewed. It's a privilege for a person to be placed on probation. It shouldn't be viewed as a gamble. It should be viewed as the court taking a chance because there's good belief that a person's going to correct their behavior. They're going to make amends to any victims. And when we don't see that happen, it needs to be viewed as aggravating. We need to take that into account in the total sentence. So that's what I'm asking the court to do. Thank you.
Thank you. Mr. Chapman?
Judge, I want to clarify one thing. There was no burglary in Minnesota. The state repeatedly referred to the burglary in Minnesota and said it was different because Mr. English's DNA was found, so that's why he admitted to it. It was also different in nothing was stolen. This was an abandoned building in Minnesota that Mr. English was squatting in for a period of time. He left things there, like I believe a candle and some plates and empty food cans, but there was nothing stolen from there, and no evidence indicated that anyone was living there or how long it had been, quote unquote, broken into. So yes, that was completely different than the other alleged burglaries, the ones that were not proven. And the state says, well, based on whatever evidence was presented, you can see what evidence was presented. It's all in the packet. It's the same reports the state is using for its criminal complaints, which I believe the court already dismissed once, and then it came back after an amendment.
Yes,
Yes,
Your Honor.
Is there any reason not to go forward with sentence today?
No,
Your Honor.
10 days of jail time credit sound right to everybody?
Yes,
that's
sir.
correct.
Mr. Harris, on behalf of the state,
Your Honor, the court has had contact with the defendant before. There's a history here, mainly drug-related. There was a concern by the court as well as the state that This is the first time that a weapon was involved. We're asking that that weapon be forfeited. And in our in-chambers discussions, it appears that the defendant is still actively using drugs. I know that in that conversation, there was an option here that he either seek meaningful treatment and inpatient treatment, or that he go to prison. We are in agreement with that thought as the court has expressed it.
Ms. Williford, anything from probation?
Your Honor, just if he were to go to a CBCF, probation would just ask that he be released on electronic monitoring following the completion of that program.
Ms. Kirby?
Yes, Your Honor, thank you. As has been noted previously, Mr. Sally does have an involvement with the court. However, that involvement has been primarily drug-related. This incident was something new, and I had expressed to the court in chambers the reason for that new involvement. And it was not something that he was trying to be malicious or commit a new crime with that weapon. It was simply for his protection. Since the court's last involvement with Mr. Sally, he's made multiple positive changes in his life. He has gotten married to somebody who is positive in his life. As you can see in the courtroom today, there is a lot of family support behind Mr. Sally. He is gainfully employed with JA Remodeling and Construction out of Monroe, and he does have stable and independent housing. Mr. Sally has made a lot of positive changes in his life. The positive drug test is obviously looming and is an issue here, but we ask the court to understand that mistakes are made when somebody is going through treatment, and to give him grace and understanding that he may need additional treatment to make sure that he can continue on in the right path. I have spoken with Mr. Sally about the potential of prison or potentially a CBCF. He is in agreement with the CBCF if the court is still willing to offer him that.
Mr. Sally, what do you want to tell me?
Mr. Judge Oda, you know we have a past, and before it was a major drug addiction. Since I've been married, I have changed a lot. I have a daughter, she lives in Georgia. I have not fully adopted, but I have adopted another boy. He's 18, he's right behind me. I've been working, I got a good job. I'm trying to do everything I'm supposed to be doing. Just have a minor slip up. I'm just hoping you just show forgiveness on me one last time, and where I can show you that I have changed and I'm not the same person that I was before.
So coming into today, Mr. Sally, I really had no idea what to do with this case. I mean, the gun is new, and you and I have 13-year history together. Never once in any of my notes, I look back through all my notes, never once have I seen anything about gun. So that does seem a little odd. I was prepared to put you on back on community control with not much of a sanction until we came up with the positive meth test. That suggests to me that we are not really that far forward from when we were before. First of all, you have no business being around a gun. Secondly, the meth seems to be consistent with your 13-year history. I don't want to send you to prison. I think it's better to send you to treatment. So I am going to put you into my community control program for a period of 3 years. I'm going to order that you enter into it, successfully complete a CBCF. The STAR program probably makes the most sense, but I'll let you and Officer Williford make that decision. Doesn't matter to me. She needs to make the referrals and get you over to that program. I'm going to order that you be on 45 days of electronically monitored supervision with a curfew upon your release. I'm also going to impose upon you the requirement that you get whatever follow-up in terms of drug and alcohol treatment they require. I'm going to order the firearm be forfeited and destroyed. I'm not going to impose a fine. I am going to impose the costs, and I'm going to give you credit for the 10 days that you have already done. If you violate the terms of your supervision or you leave the state without permission, I can sentence you to up to the maximum penalty in this case, which is 36 months in prison, plus an optional period of post-release control of up to 2 years. Is there anything else we need to do? Anything that I forgot?
No, Your Honor.
No, Your
Thank you.
Honor.
Finally, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they'll all be provided to you without charge. And we'll go ahead and get you, when's your last day for, are you serving a term for Franklin, right?
Yes, sir.
When's that done?
13.
Okay. So once that's done, we'll get you over to the STAR program. Good luck to you, Mr. Sally.
Thank you.
Thank you, Your Honor.
We're in recess.
I would agree that the behavior appears similar to the original complaint in 23 CF 99 in the sense that he's still associating with Kenneth Achterling. That's his fiance's brother. Looks like in the original criminal complaint, I had nothing to do with that case. I've just read the complaint, but it looks like Kevin Achterling brought these UTVs around and Mr. English was riding on one and had the key in his pocket. Maybe the state thinks Mr. English stole them, but the plea was to possession of stolen property, and the indication in the complaint is that looks like Kenneth took it. Similar behavior in this case, it sure looks like Kenneth was taking stuff and stashing them at Mr. English's mother's house because he also has connections to that residence, as you can clearly see in the packet. Mr. Achterling was the one who was over there fixing, I believe it was the, was it the well? I think it was the well that he was over there fixing for her, and he was using stolen parts to install a well. The ALJ did not find that Mr. English was involved in any of the burglaries, and he was revoked for absconding. Perfectly justifiable. He absconded. He was homeless for a very long time. Mr. Achterling tells me that the last stable residence he's had was with his father 7 years ago. He doesn't get along with his mother. He can't live with her. He stops by there occasionally, but he doesn't live with his mother. He's been using methamphetamine for a very long time. Homelessness is probably connected that. I know the criminal history in Minnesota is all connected to that, but his criminal history in Wisconsin consists of this case, 2 UTVs that were stolen the night before, found at his residence, and now the fact that he's been revoked and charged with other stuff that is currently set for trial. Given the criminal history is all drug related, not in any way related to stolen property, finding 2 ATVs the next morning at his house, yes, it's a Class F felony because the ATVs were worth more than $10,000, but it could have also easily been operating a motor vehicle without owner's consent. I don't think this is an aggravated version of receiving stolen property, and I don't think it calls for prison. I wish there was an option to put him back on supervision. I agree with the state that probation was essentially a waste of time here. I think Mr. English tried, but he didn't have a house, he didn't have a job, and he was addicted to meth. Probation, I think, was likely doomed to fail from the start. But I don't think that's an aggravating circumstances that makes the sentence now call for prison. Yes, he will be released soon if the court follows the DOC recommendation, but that's because he's been in jail for a very long time without any release privileges and essentially sitting 100% of his time in the county jail. I think the DOC's recommendation is appropriate. I would ask the court to follow it.
All right, thank you. Mr. English, is there anything that you would like me to know? Do you want to make any kind of statement today? You do not have to, but it's your only opportunity.
I would just like to admit, like, yeah, I did a scholarship. I didn't have a phone all the time, so I couldn't call. And I don't have a driver's license or a car. So it'd be hard for me to get from Mayfield, Minnesota, all the way up here to check in. And when I did get out of jail last time, I called my PO up here and told her I will try to get up here. My hardest. We did have a vehicle, except it wasn't reliable. It needed a back bearing and the rear tire. And so it wasn't safe to drive up here. And I kept telling her that I would keep trying to find a ride if I don't have people that I can rely on really for that stuff. I did try. I did try my hardest, and yes, I do suffer from mental disabilities that I do want to get fixed. I wish you guys had mental health stuff here to help me. And with that, I'll just let you guys know I did try my hardest. I did. Instead of not having, like, I did try to live with my mom. And last time I was up here, a dude pointed a gun at me and told me to leave my mom's house for good. And I was like, all right, whatever. I just grabbed my dog and left.
Okay. So you're basically just giving me excuses as to why you couldn't get to probation?
No, I'm just,
That's accurate.
yeah, that's accurate.
Accurate.
Yeah.
Explanations.
Yeah. I'm sorry for my behavior.
I hear excuses, not explanations. There's a difference.
Yeah.
Anything else you want me to know?
No, that's it, Your Honor.
I have reviewed the revocation order and warrant packet, and I've heard arguments from both attorneys, and now I've heard your statement, Mr. English, as to why you weren't able to, in your words, weren't able to go to probation, and you absconded for a period of a year. Mr. Schmidt alluded to, or he stated, the court probably at your sentencing.
Mm-hmm.
And he was pretty much spot on, because I remember your sentencing very clearly.
Yep.
I remember when you were arrested on this or taken into custody with this matter very clearly. I remember having discussions with you very clearly in my brain, in what I remember about that date and time and around that circumstances, the circumstances of this case, as well as at the time of sentencing. I remember very clearly that you told me that you were in a better position and that you were going to remain sober. And that was what you were looking at. I remember very clearly, you told me at the time that you then you had become a father.
Miscarriage.
What?
She had a miscarriage.
She had a miscarriage,
Yeah.
but you were going
Yeah.
to be a father.
Yeah.
And you were changing your life around completely because of, not only because you were becoming a father, but you realized at that time you were done with this criminal life. I remember that very clearly. Am I remembering incorrectly?
You remember that correctly.
I'm remembering all of it very correctly. And Mr. Schmidt, when he said the court probably, most likely the court did this, probably because of this, he wasn't even here.
Yeah.
He didn't even argue that sentencing. And I don't know, and I don't know, maybe he read a transcript, but he was spot on with guessing what the court probably was thinking at that time. And those were all the things that I was thinking at that time. Because quite honestly, at that time, based upon the history that was recited to me with regards to your criminal history from the state, even acknowledged by your attorney, Mr. McLaughlin, at the time, and by you at the time, because I had seen you for that disorderly conduct not too far in the past from this case. It was serious. You acknowledged and you admitted with those ATVs and having that property, which wasn't yours, and then telling the court that you were going to change your ways and change your life, and you wanted to make it whole with the owner of those ATVs.
Yeah, I still do.
I know you still do. And that's great, grand, and wonderful.
Yeah.
Okay, great, grand, and wonderful. But we're talking about August 7th, 2023. August 7th, 2023 is when I sentenced you originally for this. And that's when you told me all of these grandiose ideas and thoughts that you were having about changing your life, getting back on track, and making the victim whole. Because I believe, if I'm recalling correctly, the court discussed, or we talked about how in Burnett County, this is what's happening, or this is something that happens. And you're saying yes, and you're nodding your head, because that is what happens in Burnett County. We're a vacation spot where our population triples or quadruples in the summertime or in the nice vacation times. And then it goes back to our normal population in the cold times because people close up their cabins, they close up their things, and that's where they become a target. In sentencing, you've been here before in front of me, and now you're here again. You've been in Minnesota multiple times for other things, and you've been on probation. The court has to look at how serious is this, all right? It's serious in the fact that it has taken somebody's trust away. Granted, you weren't the one that went in and took the property or did the things. You had admitted to receiving that stolen property, and you had admitted in that complaint that most likely it's probably Mr. Achterling, or you mentioned Ken and those things, but you admitted to receiving those ATVs, either for converting them to your personal use or selling them for a financial gain or some other thing like that, or to give to somebody and, be a hero. And here's your UTV, I guess, not an ATV, a UTV. I have to look at you and your record, your criminal record. I have to look at you where you are today. I have to look at you and how you were on probation when I gave you that chance.
Yeah.
I said, here you go. Here it is on a silver platter for you to better yourself, to better your life, to be that person. And I understand, and I'm getting where you're probably saying with that miscarriage, that caused some issues emotionally for you and for your girlfriend. And then it caused you to spiral, and then yada, yada, yada. That's what I'm going to believe. And you're nodding your head up and down. You're saying yes, that is.
It was very devastating when I got on and she said she had miscarriage. It was very devastating for me.
And I understand that, Mr. English. I do. I also understand that there are many, many people that come in to this court. They sit in that chair. They're sitting in orange, and that they have been through the same or similar, that they have substance abuse issues and all of those things, and they don't turn to this type of crime. It's usually just the possession of methamphetamine or the other drug-related things. But yet this is something where you're taking from somebody else. Even if you're not the perpetrator who goes in and breaks into that building or shed or whatnot, takes those UTVs, you may not be that person, and that's not what you pled guilty to. That's not what you admitted to, but you admitted to receiving that property, knowing full well it was stolen. Full well it was stolen. And you wanted to convert that to whatever use you wanted to do. I have to look at needing to protect the public, and that is the community of Burnett as a whole. Here, there may be a single victim, correct. However, with looking at protecting the public, I have to look at deterrence, not only general deterrence of, specific deterrence of deterring you from doing this again, because slap on the wrist. It has to be more than a slap on the wrist, apparently, for you to understand this is not something to engage in. This is not something that you can do. And general deterrence to deter others from doing the same thing. Because again, we are a tourist county. We are where people come to vacation. They come to have their great and joyful, wonderful life. They live on the lakes. They use our woods. They hunt, they fish, they hike, they swim, they boat, they do all of those things. They come here for solitude. They come here to feel stress-free and away from their other grind of wherever they live. And the general deterrence is a sense for general deterrence is to say, hey, they deserve to have that peace. They deserve to have that solitude to come here. They deserve to not have to worry about their property when they're not physically there, because they have worked blood, sweat, tears in order to pay for what they have here. If this continues and there's no deterrence, then Burnett County loses revenue. We don't have tourists. We don't have people that want to come in here, because if it's a scary place and all your stuff gets stolen and somebody else has it, again, even if you're not the one who physically went in and took that property, even if this property was something that was stolen from Minnesota or brought here or vice versa, people don't deserve to have that fear of not having their property. I'm looking at your probationary period, and yes, it is correct. For the most part, the court looks at what the court would have done or would have sentenced at the time of the original sentence. But I also do have to look at what you did on probation, which was nothing, not one thing. You absconded for a year or so. You didn't even pay $1 of restitution, not $1.
It's hard when you can't get a job.
Whose fault is that?
Mine, I tried, and I got a job at the end before I got arrested.
Great, grand, wonderful.
Yep.
Again, great, grand, and wonderful. Hard to get a job. But again, you were given an opportunity and you didn't just blow it. You blew it, you missiled it, you threw some bombs on it, you did all the stuff and you said, doesn't matter. Because even if you couldn't get a job, you still could report to probation. You could still work with your probation officer, and you didn't even do that. So I do think that here today, it is more serious than what it may appear to be. But it does appear to be serious anyway. The receiving a stolen property, that is serious. So I do believe that this is a prison sentence. I'm going to sentence you to 2 years of initial confinement with 2 years of extended supervision. While you're on extended supervision, you will absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, regular drug testing. You will do some type of thinking for a change or breaking barriers. You will have no contact with anyone on felony probation or felony extended supervision without your agent's approval. And yes, that does include your brother-in-law and your girlfriend and any other person without your agent's approval. Anyone on felony probation or extended supervision, and in particular those related to illegal substance use and or any type of burglary or receiving stolen property or theft, those types of things. Gainful employment. And I'm going to go back to that gainful employment. There's plenty of ways that you can get a job because we have the Ruth House up in Superior. People go there all the time, multiple felonies, and they still find a job. They still work. They still work on their sobriety. They do that.
I was thinking about that while I was in here.
Well, now you have time to think because the Ruth House can give you a job. It can help you find a job. And I have people who have not had jobs in over 15 years that go to the Ruth House, that they have a job and they say, Judge, I have a job. I'm paying my way. I have an apartment now. I am sober. I've been sober for 200 days. I'm doing this. There are options and there are alternatives than absconding and not doing what you are legally required to do. There are options. So after gainful employment, I said the regular drug testing. With regards to the early release programming, you are eligible for early release programming for the substance abuse. I think you are beyond the age for the challenge incarceration. You must pay your restitution. That is part of your extended supervision. You must pay your restitution, and your restitution will be paid, must be paid by the end of your extended supervision. So $100 a month when you are released from custody, when you are in custody, I'm ordering that the court costs and fees and the restitution can be collected by the Department of Corrections at what they determine to be reasonable while you are in state prison, and that is a condition of your extended supervision. DOC shall collect your sums. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. We have your DNA. Anything that you fail to pay means that the court will enter a civil judgment against you because you're always going to owe it. Plus, I could issue a warrant and you could sit up to 6 months in jail. Very important that you pay and you pay timely. This is a felony. No use or possession of a firearm for life. No voting in any election until your civil rights are restored. Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Chapman.
262 days credit, please.
Thank you. 262 days of jail credit. We are adjourned.
I'll come talk to you down there.
Mr. Berg,
I need to go speak with Mr. Berg, Judge. Is that all right?
that's totally fine.
Thank you.
CF 208, I guess, for two. We're here with State of Wisconsin versus Joseph Berg. We have the state appearing through District Attorney Kevin Schmidt in person. Mr. Berg appears in person with counsel Daniel Chapman. We're set today in these matters for a plea hearing and an arraignment. Before we proceed, are we in victims' rights compliance?
Yes, sure.
With regards to the arraignment, Mr. Chapman, were you able to go over the criminal information with Mr. Berg?
I did not specifically discuss it with him today, but he is well aware of the charges from previous discussions, and we were prepared to go forward with the plea today.
All right, so at least at this time, not guilties on
Yes.
those. Not guilty pleas will be entered on his behalf as it relates to those. We're here for a plea hearing now, a global agreement. Can you please recite the agreement for the record?
Your Honor, Mr. Berg will be pleading guilty to felon in possession of a firearm in 23 CF 172 and to felony bail jumping in 24 CF 208, specifically count 1 for failing to maintain absolute sobriety. There will be a joint request for a PSI, and at sentencing, the state has agreed to cap its recommendation at the DOC's recommendation. The defense is free to argue.
All right, okay, and Mr. Berg, that is the agreement that you've reached?
Yes, Your Honor.
Okay, with 23 CF 172, you did say we are in victims' rights compliance?
Yes.
Okay, just wanted to make sure. And basis for the agreement and why it's in the public interest, Mr. Schmidt?
I think it's appropriate given the facts of the case. It includes a high felony with the felon in possession of firearm. It's a decision I made after after reviewing the body cam and specifically how the drugs were affecting Mr. Berg on the body cam. It kind of showed him in a rigid, non-responsive standing state for a long time until it started, whatever he was on wore off, and then he got confused and didn't know where he was.
Okay, all right. Thank you. So, Mr. Berg, I have in front of me a plea questionnaire waiver of rights form. Do you recognize the document?
Yes.
Did your attorney go over this document with you thoroughly?
Yes, Your Honor.
Did he essentially go over it with you word for word?
Yes.
And you understood everything on that document?
Yes, Your Honor.
Is that your signature on the second page?
Yes.
You were pleading guilty to 1 count of felon in possession of a firearm in 23 CF 172 and 1 count of felony bail jump in 24 CF 208. You are 38 years old. You have 10 years of schooling. You can read, write, and you understand the English language. No drugs, alcohol, or other medications other than a prescription medication within the last 24 hours?
That's correct.
And have you taken that prescription medication as prescribed?
Yes, Your Honor.
And is that a prescription that interferes with your ability to comprehend or understand anything that's going on?
No, Your Honor.
So you are in a state right now where you completely understand and comprehend everything.
Yes.
Now, did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney go over with you the maximum possible penalties you face?
Yes.
Because you're being charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on that first page of that plea questionnaire. Did your attorney go over those rights with you?
Yes.
Did he go over them thoroughly with you?
Yes.
And do you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you also understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand with 23 CF 172, possession of a firearm by a felon, the state would have to prove on or around September 16th, 2023, you possessed a firearm in Burnett County, Wisconsin, having been convicted of a felony in St. Croix County in Wisconsin, cases number 17 CF 262, 15 CF 199, and 04 CF 335, and in Washburn County case number 09 CF 92. So do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $25,000 or imprisonment of up to 10 years or both?
Yes, Your Honor.
You also understand that with regards to the 24 CF 208, the state would have to prove on or around September 7th, 2024 in Polk County, Wisconsin, having been charged with a felony in Burnett County case number 23 CF 172, and having been released from custody, you intentionally failed to comply with the terms of your bond by maintaining absolute sobriety. Is that the one he's pleading to?
Yes, Your Honor.
All right. And so do you understand what the state would have to prove?
Yes.
Do you understand that upon conviction, you do face a fine of up to $10,000 or up to 6 years of incarceration or both?
Yes.
Do you also understand that there's a recommendation to the court here, a joint recommendation for the court to order a pre-sentence investigation report in which the state is capped at whatever the Department of Corrections recommends for sentencing? Do you understand that I'm not bound to follow any recommendations?
Yes.
And do you understand what that pre-sentence investigation report is?
Yes.
And it's going to give me a whole lot of information, as well as the attorneys, about you, about your life, about your criminal history, about your upbringing, mental health, physical, all of those things, with that recommendation for sentencing from the Department of Corrections. So you understand I'm not bound to follow the Department of Corrections recommendation.
Yes.
And I'm not bound to follow the state's recommendation.
Yes.
Or the defense's.
Yes.
And so do you understand that I, in my discretion, can sentence you to the maximum possible penalties for each of those charges if I find it is warranted?
Yes.
Do you still wish to proceed and enter guilty pleas?
Yes, Your Honor.
Do you understand that you're pleading guilty to felonies? As such, you will no longer be able to use or possess a firearm for life?
Yes.
You will no longer be able to vote in any election until your civil rights are restored?
Yes.
Did you go over both of those criminal complaints with your attorney?
Yes.
And in particular, there is that section in both of them called the probable cause section, where it basically says what happened those days and why you were charged with crimes?
Yes.
And for the most part, as it relates to the two charges you're pleading guilty to, are those facts accurate?
Yes.
Are you admitting that you did in fact possess a firearm and you are a felon?
Yes.
Are you admitting here today that you in fact did violate intentionally the conditions of your Burnett County bond?
Yes.
Are you pleading guilty to those charges because you are guilty of those charges?
Yes.
Mr. Chapman, may the court use the probable cause section of the criminal complaints to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to these charges?
No, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at these matters thoroughly?
I assume so. It seems that way.
Has he discussed with you the facts of this case
Yes.
and what the state would need to prove?
Yes.
And did he discuss with you any potential for any defenses or possibly a lack of defenses in the cases?
Yes, Your Honor.
And so he negotiated on your behalf and he came up he got this agreement with the state?
Yes,
And are you satisfied with his services?
yes.
Do you have any questions for the court or your attorney before I proceed?
No, Your Honor.
Then as to 23 CF 172, possession of a firearm by a felon, how do you wish to plead?
Guilty.
As to 24 CF 208, count 1, felony bail jump, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those 2 charges. The other counts and charges will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. And just briefly, quickly, Mr. Chapman, because there was a time where Mr. Berg may or may not have been there during the incident of this matter. Do you believe he's competent right now to enter these pleas?
Oh, yes. During the incident, it was drug and alcohol related, in my opinion.
And he's doing great since then.
I have never had any question about Mr. Berg's competence.
All right. And you believe he's entering his pleas freely, intelligently, and voluntarily?
Yes, he is.
Full understanding of the facts and what the state needs to prove?
Yes.
And any potential defenses or a lack of?
Yes.
All right. Okay, then the judgment of conviction is entered and the court is going to order pre-sentence investigation report. Long form agent does not need to appear, but should be available by telephone if questions are needed to be answered. As to bond, I'm going to guess you're not asking to revoke bond at this time, Mr. Schmidt?
I am not.
Bond will remain active. You are under all of those conditions of bond. If you violate bond, I'm letting you know right now that gives the state the ability to do what they want with regards to arguing. Right now, they're capped at the PSI, so follow your bond to the letter, okay? And when the DOC, Department of Corrections, contacts you for your input in this, you are ordered, you have to comply with them. It's only in your best benefit if you do. I just need to make sure that I have your address is still on Valley Drive.
Yes.
And telephone ends in 3623.
No, Your Honor.
May I get an updated?
It is 612-528-8330.
May we send you text message notifications if we need to?
Yes.
Okay, so I'm not revoking bond at this time. I'm ordering you to comply with DOC. You must report immediately after here to go to DOC just to make sure that they have your info and all of those things, but they should. They may or may not want to get started today. I'm not sure, but since you're coming from such a distance, that's why I'm saying you should just go report today, see if they want to have any contact.
Where is that?
It's kitty corner from the courthouse.
Okay.
You should be able to see it when you go towards Webster. It's on your right.
Okay.
Okay.
Just pull out of the parking lot, turn left, and it's right up.
We need a date for sentencing. And Mr. Chapman, it's going to go into the new year. Is that okay?
Oh, yes.
I can do January 6th. Wait, did I sentence you? No. I can do January 6th, either at 9 or at 11 or anytime in the afternoon, or January 7th. Oh, wrong week. Sorry. I need to look at a Schmidt week. I can do January 20th, or I must have had something come off because the week of the January 20th, 21st, 22nd, and 23rd, I'm wide open.
That's still Jose's week.
Oh, darn it.
He did the week of the 12th.
I know, but I have, we're booked solid. Well, I guess January 26th, can you do 1 o'clock?
No, Judge, I need to be in Polk County at 1 o'clock. I am back in front of you at 2:30.
I guess I can take off my prelims. I can do it at 3. Do 3 to 4. All right.
Just so you know, Judge, Mr. Berg is on probation and doing well right now from his Polk County matter. So if you're
I thought he had a sentencing.
if you're trying to think I have to get this done as soon as possible and you're trying to squeeze in prelims, I think we're fine waiting, but
My thought was not trying to get it done as soon as possible, but victims
understood.
trying to get it done as soon for any victim involved. So. that's
Okay.
all.
The January 26th at 3:00 is just fine.
Okay, we'll see you then, January 26th, 3:00. Follow your bond to the letter, okay? All right.
Best thing you can do.
Anything further, Mr. Schmidt?
No,
Mr. Chapman?
No, Your Honor.
All right, then we are adjourned.
I don't know if it's been part of the court's thinking or if it's been, Commissioner Krupa's other things, but our office is able to be double booked again on Thursdays for prelims if you
If we
want to
need
start
to,
doing
no
that
one ever
again.
knows what to
Yeah.
do, and that's good.
I do
Usually
not
the
see
prelims
Mr.
with Mr. or Commissioner Krupa get scheduled by clerks and or my assistant. Sometimes I do, but it's fine, and they'll do it. She'll see I blocked it.
I do not see Mr. Gaffney, Judge, but I will
I
stick
have
around.
the jail coming in.
He shouldn't be in jail, is
Should
he?
not be in jail. I don't know why the jail's trying to come in. I can check the jail roster, but who's in custody right now? He should, I had no indication that he should be in jail. So I'm just gonna check the roster. Yeah, I'm not either. Who's in custody in jail? Because I don't have anyone on my calendar the rest of the morning who should be in jail. Who's in jail? Can't see or hear you. I don't have him on my roster. So unless he was picked up
I'm
right
just
after
checking
they did
Vine
the
Link
roster.
now.
Because they did it at 6 this morning, so I don't know. Mr. Oya,
Yeah.
you're not supposed to be in my court today.
Oh, I'm not even sure what they got me for.
What are you here for? What do you think you're here for?
I'm not even sure. Really.
For what?
I'm not even sure, really.
I don't have you on my calendar right now for anything, and I don't think you're being revoked.
No.
On anything. Yeah, I didn't think so. So I don't think you have anything right now.
Okay.
All right, thank you.
That Jonathan? Bradley Belial, otherwise known as Oyat.
Okay, well, whatever we
I'll stick around
can.
10 minutes or so.
What?
I'll stick around.
25B8, 26. Good morning, sir. Your name? So we're gonna adjourn this one last time. It's gonna be November 5th, okay? Lisa, what time?
10:30.
At 10:30. Okay? Good luck to you. Mr. Ashton, what time does your case up?
I'm not sure.
What time's that case up?
8:30.
Well, are they ready on that?
I sent him to talk to the Roseville prosecutor. I don't know what happened. I never
Did
got
you
filed.
talk to the Groseville prosecutor?
I said I was here. And I told you to go out there and talk to the Roseville prosecutor.
That's all right, that's all right.
So,
You can call him up, tell the prosecutor to come on in here. Are we ready on Jesse Lee Stroud?
yeah.
Jesse Lee Stroud, 25B1493748.
Attorney Mike Collins, House Counsel, Key 65417 on behalf of Mr. Stroud.
Mr. Stroud, your name?
Jesse Lee Stroud. Judge, today's the date and time set for sentencing. We've had an opportunity to review the pre-sentence investigation report. We'd like to announce that there are no deletions, corrections, errors, or omissions. If I may briefly speak on my client. So my client's got a prescription bottle with, I guess maybe it's a higher level of of a ibuprofen that would be medically prescribed. There are some benzodiazepine
Right.
pills in the container. Why they're there, how they're there, it doesn't change the fact that they're there. So we do have possession. I'm not seeing use per se. Your Honor, I'm going to ask that you strike the intensive outpatient treatment. He's under medical.
They didn't really request or recommend that. It's just attending complete substances of abuse group.
Yeah, it's got the second box checked.
I don't know why we do that. That's ridiculous. I don't even know why that's on there.
Thank you.
You know, I don't.
And as you see, he has a medical condition related to a personal matter that he is under medical care with right now. So he has bigger issues going on with his life. I'm going to ask the court to adopt the recommendation. I think it is fair. The ETGs and preliminary breath tests, I would just ask as mandated by the probation department at their discretion. Aside from that, Judge, he has no marked past criminal conviction history. I don't know why those pills were in the bottle. Quite frankly, it doesn't matter. He's in possession of them. And I would just ask that the probation match the considerations that are before the court. In fact, I would ask that the court do deviate to 6 months of probation under 333-749.
Sir, anything?
Yes, sir. I'm working 2 jobs right now and I'm trying to pick up the third. So if you just do the probation, it would really help me out.
9 months probation. You cannot leave the state without the consent of the court or violate a law. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I'm going to order that you submit to chemical testing PBTs and ATGs monthly. I'm going to order that you attend the substances of abuse group program to Class A training center, that you serve 1 day on the court work program, $35 charge for that. 2 days of community service. I'm going to give you until December 1st to complete your community service. Fines $50, costs $75. $75 victims' rights fee, $50 justice assessment. So fines and costs are $250. Attorney fees are $40 for $290. You have a screening fee of $60 for $350, plus your court work program fees of $35 for $385, and $180 in probation fees. Should be $565. If you violate, your probation could be revoked. Again, I am taking this under 7411. You could be incarcerated for up to 90 days. You have 21 days to appeal and 14 days to apply for a court-appointed lawyer. Do you understand that?
Yes, sir.
Okay, Lisa, what do you have for a review hearing for me?
Give me 1 second.
Can you pay all this today?
No, sir.
How much can you pay today?
Nothing, sir.
How much can you pay? You get paid every Friday?
Yes.
Can you pay?
I get paid weekly from Burger King now because I just started.
Can you pay 50 per week?
Yes, sir.
50 per week, and I'll just start that next Monday, which should be October the 27th, okay? If you need more time at any point, just tell me. I'll give you an extension. Come in here and talk to me on or before the due date, or call the court and we'll go on Zoom on or before the due date. I'll give you an extension, all right? Get away from those pills. So what did we have, Lisa?
July 1st of 26 at 9 o'clock.
July 1st of 26 at 9 a.m. will be your court date, okay? Or your review hearing date. So you're going to go down the hall. She's going to print out a review hearing date. And then you go back over to probation where you will be interviewed. I'm sorry, they will explain the order to you in more detail and answer any questions, okay? Good luck to you. What is the Grosio prosecutor, 237?
Hello?
Are you ready to go on this Aston case?
Yes, sir.
Why don't you bring the file in and we'll call it, okay?
I do, sir.
Thank you.
Thank you.
Thank you. How are we coming in the rest of, okay. Sure.
I don't think we're gonna have some new shows. For sure.
Why don't you call these other prosecutors, see if they have anything else? Call Woodhaven and Brownstown. Tell them I'm gonna start a hearing. If they have anything ready to bring it in now, so I'll take it before the hearing starts.
Hey, I think we're gonna pause here, please. Yeah, look, Petrol.
All right, stay seated. I'll come back out in a few minutes. As well, a copy of. All right.
This is your stuff.
People against Scott Aston. People against Scott Aston, 258-255-82573. Your appearance, Mr. Lane?
Good morning, Your Honor. Matthew Wayne on behalf of Roseville Township.
Mr. Aston?
Scott Aston, defendant.
All right, so you referenced in your, Mr. Wayne, you referenced in your brief, your case brief here, and then defendant filed a reply brief. You referenced that you'd given me a packet of information when you and I and Mr. Aston were in chambers, I believe, right?
Yes, sure.
And that was a few weeks ago, and I'm trying to figure out what it was that was. What did you hand me?
So there was a case in the Wayne County Circuit Court from approximately 5.5 years ago. Isaac Akana LLC,
And
the defendant, and Roseville Township as the plaintiff. This was before the Honorable Judge Gillis.
Okay, and you provided, I believe, as well, a copy of that to Mr. Aston, right?
Yes, if I remember correctly, copies were made with one of our staff.
Is that true? You received that?
Yes.
I just wanted to double check on that. How do I say this? You don't have to have a lawyer, Mr. Aston. They're charging you in your personal capacity with a civil infraction. You have the right to represent yourself on the most routine of civil matters or the most serious criminal matters if there was ever a time you were charged with something serious. I'm just suggesting to you that you all want to get a lawyer. I mean, I read your brief, it's fine. I suspect you got it online from somebody or somebody ghost wrote it or it was an AI put together thing, but whatever it is, it's fine. But now you're in court and you have to verbally enunciate. And I'm sure that this probably means a lot to you. I mean, I don't know if you strictly had this home for an Airbnb business or not, Airbnb business. If that's what you use it for, the income that's generated, I don't know, but you might want to do that. If you want to do that, I'm going to give you an adjournment. If you don't want to do that, then we're going to proceed right now.
We can proceed, Your Honor.
You don't want to hire a lawyer.
On appeal, I believe it's a de novo review.
Okay. All right. How do you intend to proceed here?
Your Honor, so you have the legal underpinnings of each party's position. The witnesses that the township intends to call today are the individuals who can testify to personal knowledge regarding the property, what they witnessed, their interactions, if any, with the property, and the notice that was given to the defendant regarding the issues with the property.
Okay. So you're going to call witnesses?
Yes, Your Honor.
Yeah. All right. How many witnesses do you have?
2, Your Honor.
And do you wish to give an opening statement?
No, Your Honor.
Do you wish to give an opening statement, Mr. Aston?
Sure.
Okay.
Defining the facts is the crux of this litigation. Pursuant to the definition set forth in the Township of Roseville zoning ordinance, which both parties in this court are bound by, fact which is not in dispute is defendant lets and or leases a dwelling unit located in a single-family residential district on a temporary and or transient basis, which is a permitted principal use under the zoning ordinance. What the Township of Roseville is trying to do with this litigation is amend the zoning ordinance by judicial fiat. The current zoning ordinance does not place any restrictions on the amount of time a dwelling unit can be rented for. Should the township wish to regulate and or restrict the duration of a rental of a dwelling unit in its single-family residential districts, the proper procedure for amending the zoning ordinance is for the township to hold public hearings on the matter and amend the zoning ordinance if necessary after that public input. For the reasons stated herein, I urge this court not to legislate from the bench and find defendant not guilty of the zoning ordinance violation as asserted by the township and award costs to defendant.
Okay. Call your first witness.
Your Honor. Actually calls Roswell.
Yeah. John. Your name, sir?
Roswell.
Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God. Okay. Give me 1 second, counsel, all right? If you could find it. All right. Sir, spell your name for me.
First name Ross, R-O-S-S, last name Quero, Q-U-E-R-R.
Thank you. You may proceed, Mr. Wayne.
Thank you. Morning. Good. How are you? Fine, thanks. We know your name. What's your position?
Community Development and Downtown Development Director with Roseville Township.
And how long have you been an employee of Roseville Township?
A little over 3 years.
Okay. I'd like to take you back to on or about August 20th, 2025 in Roseville Township, County of Wayne, State of Michigan. Something happened that day that brought you here today?
Yes.
Okay. So tell me why you're here.
It's been routine since my 3 years for the township to actively pursue Verbo Airbnb listings in the island. And we came across this listing. It was pretty obvious that it was a violation of our ordinance as per Wayne County Circuit Court ruling.
Objection.
What's your objection?
It's not in violation of the township zoning ordinance.
Okay. Wait a minute. Stand up. Tell me what your evidentiary objection is. He said it was pretty obvious that it was not compliant with the zoning in accordance with the decision of the Wayne County Circuit Court. So I want to know what your legal objection is to that.
Defendant, myself, lets and or leases a dwelling unit located in a single-family residential district on a temporary or transient basis, which is a permitted principal
So
use.
what is your legal objection to his answer? You said you objected. I'm not sure what your objection is. You might disagree with what he's saying. I'm going to overrule your objection. Continue your answer.
That was the short of it.
Thank you.
So,
All right. And so again, just to reiterate here, so you said as part of your job, you're just going to focus the township on,
yeah, actively pursuing Verbo and Airbnb listings on the island.
okay. And so for the address in question, you said we, so who would we be?
Me, myself, and zoning administrator, James Brock, and, our code enforcement officer, newly recorded, is kind of a team for.
So this is something you discussed with your colleagues?
Correct.
Okay, so we're talking about 27595 Alva in Grossfield Township, correct?
Correct.
Okay, so how did it come to your attention that this property is being offered as a short-term rental?
Yep, saw it on a Verbo, listing.
Objection. Short-term rental is not defined by statute. According to the Grossfield Township zoning ordinance, chapter 285-24.5.
Is there any other legal objection that you have?
In carrying out its designated duties, an enforcement officer shall administer the chapter precisely as it is written and shall not make changes or vary the terms of the chapter. Short-term rentals has not been defined by ordinance or by the courts.
Can you define what you mean when you tell us short-term rentals?
Yep, short-term rental is, anything less than a month-to-month basis. So, our common practice has been, if you are, if you rent out a property from a landowner, you have a lease agreement, that's not a short-term rental. A short-term rental is anything less than 30 days at a time. It's been our drop rate.
So, and you indicated that through Verbo and through Airbnb that the subject property was being listed as short-term rental in conformity with the definition you just provided.
Correct.
Okay, so what did you do at that point?
I scrolled down the listing, saw the name, looked up the name. It was a resident on the island, sent the notification that they were in violation.
I'm sorry, I stopped there. So who's the resident we're talking about?
Max Aston.
I'm sorry?
Max Aston, or Scott Aston, I'm sorry.
Okay. Is it individual here today?
Yes.
Please identify him for the course.
The record should so reflect the witnesses identified the defendant.
So through the Department of Community Development, correspondence was sent to the defendant?
Correct.
This is Township's proposed Exhibit 1.
Yes, you may.
Sorry.
You're going to hand that one to the, let's have it marked before. You don't have that document in your hand marked yet, correct?
No, Your Honor.
Okay, so let's have it marked Peoples 1, and then you can approach the witness and show the witness if you'd like.
Take a second there just to review that.
Is that marked plaintiff's proposed exhibit or People's proposed exhibit number 1, sir?
Yes.
Okay, can you identify that?
Yes.
Tell us what it is.
It is a notice of violation of operating Airbnb dated May 5th, 2025.
Okay.
So there are 3 pages, correct?
Yes. And then on the second page is June 23rd, 2025, a letter from James Brock notifying the individual that they're in violation, and then a final one on July 29th, 2025.
Even though the correspondence, at least the second and third notices that you just referenced, even though they were issued in the name of James Brock, the zoning administrator, have you seen these before?
Yes.
Okay. Are you familiar with the content?
Yes.
Okay. So the first notice that you have, what's that notice about?
Take your time.
Yeah. It's our general template notice of violation.
Okay. And it's letting, who know what?
That they're in violation of the township municipal codes by operating an Airbnb.
Okay. Is there any amount of time to remedy the violation?
10 days.
Okay. Flipping to the second page, and that's dated when?
June 23rd, 2025.
Okay. What's the substance of that notice?
Basically providing the resident information about the case, the Wayne County Circuit case, providing that information that, residential property cannot operate as short-term rentals, and failure to discontinue the use of the property as a short-term rental would result in the township taking legal action against them.
Is it so? It's fair to say by the time that second correspondence would have been issued, that the remedy still wasn't, rather that there was no remedy to the violation at that time, correct?
Correct.
Okay. And then the third page, if you would.
It's basically essentially reiterating the same letter as before, but
What's the date on the third document?
July 20th.
July 29th.
Yes.
So by that time, is it fair to say that the violation still wasn't remedied?
Correct.
Okay. So earlier you said that you believe that the subject property was in contravention of the township's ordinances regarding rentals. So, and now you're familiar with different districts, correct, the township has?
Yep.
So for the subject property, and what district is that in?
That's a residential district.
Okay. So to your knowledge, does the code of ordinances specifically enumerate uses for residential districts?
Correct.
Okay.
Are you moving for the admission of that document?
Yes, I'm sorry.
Any objection to that, Mr. Aston?
No.
Plaintiff's one or people's one is admitted. You may proceed. I'm sorry.
Forgive me. So. Now, to your knowledge, are there any districts within the township that allow for the types of business activities as in short-term rentals if the subject property was part of?
Yes, although it's not defined as short-term rentals in the ordinance, on Macomb Street districts and the airport district, bed and breakfasts are permitted through special land use, which is where this sort of transit sort of activity would be permitted. But that takes special approval through the planning commission.
So I have you straight. So transient use is permitted in certain districts, but not in the district in which the subject property sits.
Correct.
Okay. And so to your knowledge, was the violation ever remedied?
No.
Your Honor, no further questions. I reserve the right to recall a witness for rebuttal.
Thank you. You can proceed. Any questions?
No questions, Your Honor.
You can step down. Thank you. Call your next witness.
Time for calls. Zoning Administrator James Brown.
All right. I'm going to ask you to raise your right hand, sir. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth so help you God.
I do.
It's BROCK, correct?
BROCK, that's not true. You can proceed.
How are you? Good. Fine, thanks. So what do you do?
I'm the zoning administrator for the Roseville Township.
And how long have you been in the employ at Roseville Township?
About a year and 6 months.
Okay. So as with the previous witness, I'm going to bring you back to honor about August 20th, 2025, Roseville Township, County of Wayne, State of Michigan. Something happened on that day that brought you here today?
That's correct.
Something happened on that day that brought you here today?
Yes, that's correct.
Okay. So please tell us why you're here.
We observed a short-term rental going on at a specific address on Roseville, and
Wait a second, is that for that address be 27595 Elba?
That is correct.
Okay, I'm sorry, is your definition of short-term rental, does that comport with the testimony from the previous witness?
That is correct.
Okay, go on, please.
So we had observed a short-term rental happening at this address that I mentioned before. We had sent multiple notices at this point to try to remedy this issue and make them aware of the fact that it was not something that was allowed to be done. And at that day and time, it was observed that it's still been up and running. And again, that is against our ordinance.
Okay. Can I move this quickly here? I'd just like to hand you a copy of this is exhibit A for the township.
Wait a minute. Exhibit A?
Did I say one the first time?
What did you have that first one marked, Tabitha? Yeah, so let's have this marked, exhibit 2.
This is the same thing. This is the same exhibit, Your Honor.
Oh, I see. Okay, so it's already been entered as exhibit 1.
Yes.
That is what you have handed him.
Yes, Your Honor. I'm sorry.
That's okay. Is that true, sir? Is that what you have?
That is what I have.
Okay, ask your next question.
You're familiar with the correspondence that's in front of you?
That's correct.
Okay. Did you send or prepare these letters?
That is correct. That it's up.
Okay. And 3 of them, correct?
Correct.
And each of them was sent because there was a violation of subject property, correct?
Correct.
And to your knowledge, was this violation ever remedied?
No, it was not.
Okay. No further questions, Your Honor. I would like to again reserve the right to recall the witness on rebuttal if necessary.
Okay, Cross? Any? You can step down. Thank you. Call your next witness.
No other witnesses for the township, Your Honor.
Do you have any witnesses, sir?
I do not.
All right, so you're just gonna argue, right? Everybody? Go ahead.
Yes. Your Honor, we've had a chance, to have relevant on-point case law regarding short-term rentals in Grove Seal. You had copies of the ordinances. This seems to come down to not a question of whether there was a property that was short-term rental, however one wants to determine it. The question was whether in the residential district in which the subject property sits, whether that was permissible. And I know Your Honor knows, and as you've read, Michigan courts have determined that when, aside from specific uses that are enumerated in municipal code of ordinances, if it's not specifically listed, then it's not permitted. Michigan courts have also agreed as that short-term rentals fall under the definition of motels, and specifically within Grove Seal, because this seems to be a sticking point. Transient uses are permitted in certain areas, but as you've heard and as Your Honor has read, those uses are within 2 specific districts: the Macomb Street District, then the Airport/Light Industrial District. The subject property is not within either of those districts, therefore it is not permissible for a short-term rental such as the property, how it's being offered and how it has been offered, how it was offered on the date in question. That was permissible use. And so again, I respectfully ask this court to find the defendant responsible.
Thank you.
Thank you.
Any argument, Mr. Aston?
In Kaiser versus Casey Township, exhibit 1, page 5, may I?
Sure. I believe that was attached to your brief.
Correct.
I read it. But you can go ahead.
The Supreme Court reaffirmed the propositions that the courts do not sit as the zoning commission, and the people of the community through their appropriate legislative body, and not the courts, govern the community's growth and life. Zoning ordinance chapter 285.24.5, community development director, zoning administrator, and other administrative officials, exhibit 2, states, in carrying out their designated duties, all such enforcement officers shall administer this chapter precisely as it is written and shall not make changes or vary the terms of this chapter. Further, in real, Further in Graham, Spring Lake, Supreme Court docket 159-874 of 2010. Exhibit 3. Supreme Court stated that the courts must use definitions provided in the ordinance and must not search field for meanings where the act provides its own. They said we must follow the definition provided in the ordinance. See Butterfield Theaters. We need not, indeed we must not, search a field for meanings where the act supplies its own. Plaintiff also refers to Riem in plaintiff's case brief, but plaintiff's conclusionary statement, interpretation of single-family dwelling, holding that its definition expressly excluded motels and that such short-term rentals are motels, is incorrect. The court held that the Riem property fit the Township of Spring Lake's ordinance definition of motel and not the definition of single-family dwelling. The Riem holding is inapplicable to this litigation as defendant is not being charged with violating the Township of Spring Lake zoning ordinance. And two, the Township of Rose Hill must apply defendant's facts to its own zoning ordinance definitions. Township of Rose Hill zoning ordinance definitions, which must be applied to defendant's facts. Defendant's Exhibit 4, excuse me.
Yeah, are these all for me, Mr. Aston?
The court, yes.
Okay.
Defendant's Exhibit 4 is the zoning ordinance, Article 1. And it should be noted that Article 1 is 225 pages long. Exhibit 4 only contains pages 1 of 32, which are applicable, which apply to defendant's facts in this litigation. Zoning ordinance rules of construction, Chapter 285, 1.2A10, which is Exhibit 4, page 2 states, whenever a word or term hereafter applies in the text of this chapter, its meaning shall be construed as defined herein. Words or terms not herein defined shall have the meaning customarily assigned to them. Zoning ordinance single-family residential districts intent. It's Chapter 285, 3.1. Defendants Exhibit 5.
So we're gonna get these out. You keep them on.
States, the regulations concerning single-family residential districts provide for a residential environment consisting predominantly of low-density, single-family dwelling units. Single-family, zoning ordinance, single-family residential districts.
Do you have anything that says that they cannot regulate? That the township cannot have an ordinance that prohibits Airbnbs? Is that what you're saying?
There's no ordinance that if you let me finish here, the definition of dwelling unit in our zoning ordinance, which is Exhibit 4, page 15, states that a dwelling unit is any building.
Exhibit 4, page 15.
Exhibit 4, page 15, which would be on your, it's chicken scratch, but it's C, tab C.
Okay.
Dwelling unit, so single-family residential districts, the intent, which is Exhibit 5 says, regulations concerning single-family residential districts provide for the residential environment consisting predominantly of low-density, single-family dwelling units. Single-family residential units, Exhibit 6, which is right here, permitted uses, says in single-family residential districts, no building shall be erected and no building or land shall be used except for the following uses. Principal uses, single-family detached dwelling units, meeting the standards of 285-3.4E. 3.4E pertains to the quality of construction, so it doesn't apply to this case. But it says single-family dwelling units. So then if we go back to the definition of dwelling unit in the zoning ordinance, which is again Exhibit 4, page 15, which is B on your tab, it states any building or part thereof containing one or more rooms, along with bathroom and kitchen facilities, designed as a self-contained unit for occupancy by one family for living, cooking, and sleeping purposes, either continuously, permanently, temporarily, or transiently. It should be noted that plaintiff states in its plaintiff's case brief, page 3, Article 2A, that no transient uses were permitted in the township's R1B single-family district. This statement is clearly a frivolous claim and lacks any legal merit, as transiently is included in the zoning ordinance definition of dwelling unit. And single-family detached dwelling units are permitted principal uses in single-family residential districts. Furthermore, the plaintiff also made this statement in the bottom of page 1 of its brief in support of plaintiff Groseal Township's motion for summary judgment and Groseal versus Isaac, case number 2020-1015-495-CC, which that court relied upon in granting plaintiff's motion for summary judgment. Plaintiff's attorneys cannot make the statement before these courts in good faith when the zoning ordinance definition of dwelling unit includes transient uses. Therefore, defendant is entitled to sanctions. So if I go on further, so we have dwelling unit, the definition which includes temporarily or transient. Again, Exhibit 4, page 2 defines or indicates the connected terms, conditions, provisions, or events may apply singularly or in combination. Or means and or. If we go to temporary use in the zoning ordinance definition, which is Exhibit 4, page 29, a use which is not permanent to the property and is permitted to exist for a specific reason for a specific period of time. If we go to use, which is also defined in the zoning ordinance, Exhibit 4, page 29, the purpose for which land or premises or a building thereon is designed, arranged, or intended, or for which it is occupied, maintained, let, or leased. Let is not a defined definition in the zoning ordinance, but Cornell Law School's Legal Information Institute, which is Exhibit 7, excuse me, defines defines, I apologize. Defendant's Exhibit 7 defines let as a property law term that refers to the act of leasing and or renting out real property by a landlord to a tenant. Let has largely been superseded by lease in American English, although it remains widespread in British English. Lastly, transiently is also not defined in the zoning ordinance, but per the Cambridge Dictionary, Defendant's Exhibit 8, transient is defined as someone who lives only temporarily in a place.
I want to make sure you're giving him copies of all of these things too.
They're included in the brief. Okay. I apologize, but I can get these.
Do you have all these documents he's referencing?
Yes.
Okay, good enough.
Again, transiently is also not defined by the zoning ordinance per the Cambridge Dictionary. But per the Cambridge Dictionary, which is Exhibit 8, transient is defined as someone who lives only temporarily in a place, lasting only for a short period of time, temporary. Thus, pursuant to the zoning ordinance definitions, which plaintiff, defendant, and the courts are required to abide by, defendant is leasing a dwelling unit located in a single-family residential district on a temporary or transient basis, which is a permitted principal use. The zoning ordinance does not place any restrictions on a temporary or transient lease. Therefore, concluding, pursuant to the zoning ordinance, administrative officials shall administer the zoning ordinance precisely as it is written and shall not make any changes or vary the terms of the zoning ordinance. In addition, in Kaiser, the Supreme Court reaffirmed that the propositions that the courts do not sit as a super zoning commission, and that the people of the community through their appropriate legislative body and not the courts govern the community's growth and its life. So based upon the foregoing, what the township is again trying to do in this litigation is amend the zoning ordinance by judicial fiat. The zoning ordinance does not place any restrictions on the amount of time a dwelling unit located in a single-family residential district can be rented for. The proper procedure for amending the zoning ordinance is for the township to hold public hearings on the matter and amend the ordinance if necessary after that public input. Wherefore, defendant respectfully requests that this court enter an order dismissing the charge against the defendant, awarding defendant his costs, and awarding the defendant any additional relief this court deems necessary and just.
Thank you. Mr. Wayne?
Yes. Your Honor, heard the arguments from the township, your arguments from the defendant. We had an opportunity, court has, of course, to read the briefs and to read the applicable case law. And you have the factual underpinnings of the township's case as presented through the testimony of the zoning administrator and the community development director. Let this court know how this short-term rental was brought to their attention and their personal knowledge and evidence of the existence of this violation. I believe the township has satisfied its burden by the preponderance of the evidence that the defendant is responsible for violating the ordinance in question. So the township respectfully would ask this court to find those sanctions. Thank you.
Thank you. Lisa, when is Grosjean back here?
They are back on November 5th and November 19th.
I'm gonna adjourn this to November 5th. I want to look at a couple things more closely, okay? I spent considerable time reading both of your briefs here, but I still want to go back. November 5th at what time? Let's make it later, 10:30, so Mr. Aston isn't waiting around, okay? So that'll be at 10:30 on November 5th. You guys can return, and I'll tell you my ruling at that time.
Your Honor, if I may, does the court have this time any need to have any further testimony from the witnesses?
No, the witnesses don't have to return.
So this would excuse their appearance.
Oh, yeah. They don't have to return. Nobody. Yeah. Okay. Thank you very much. I am giving both of you a copy of the exhibit. So you can approach up here, wherever that is, Tabitha, give them it. And we'll retain the original, I suppose. Okay.
Thank you, Your Honor.
Thank you. Okay.
She said, "Right." Also, if you want credit, don't forget down direction. Yes.
Yeah.
Do you need this? No, you missed that. That's me.
Which of these scans? Yes. Whatever they gave me before, the stuff they gave me before, it's in that jacket that I haven't had full of copies. All right, we have anything else ready, anybody?
I think Mr. Baldwin might have a couple.
Mr. Clay is ready also.
Okay, you have Mr. Clay's phone?
No, the rules of prosecutors got to get.
Okay, okay.
There, so you say that. I understand. Yeah, what German or no show?
Just me.
Well, then you got a red clock. You're German, yeah.
Is that person in here already?
Who's that?
They're not, it's GFO. I told them I was waiting on for the attorney. I'm just requesting an adjournment.
Where's the lawyer? Is he here? Where's he at? Do you think he didn't show up because you told him not? He misunderstood you or something?
No, I haven't spoken to him yet. I just called recently to see where he was. It just went to voicemail, so I went to voicemail.
Is he coming in person?
Normally it's Zoom,
What time is that scheduled?
9:15.
Just give me the file and I'll go ahead and adjourn it.
Thank you.
We're babysitters. You know that, right?
Probably babysitters.
I mean,
Seriously, please, my these days. Very good.
Okay. GFL Environmental, 25E149604. Your appearance,
Caitlin Foley, Potter, 100,000 Township.
the defense lawyer didn't show. Lisa, would you please call him? I don't know where he is, but if you can call him and tell him we're adjourning it a couple weeks. The prosecutor's fine with that or moving for that, actually. So that's what we'll do. Nevin Todd Janot. 25B147755 A, B, and C. Did you have a lawyer, sir?
Mr. Baldwin.
Okay.
He's in a breakout room with the defendant.
Seconds here. Just have a seat, please. So we got Torrance. Is Torrance out here? Did you have a lawyer?
That's Mr. Baldwin as well.
Let's take a few minutes. Everybody stay seated.
Yeah, but I would be. Yeah, I'm just going. No arms. Girls up prosecutor. You do like me to get time, really? You said it's on my house. Oh, okay. That's son.
Miranda Rose Baldridge, 25B149433 A and B. Come on up, ma'am. Your name? Counsel, your appearance?
Good morning, Your Honor. Justin Zaid appearing on behalf of Ms. Baldridge, present in the courtroom.
All right, does she stand mute and waive formal reading? She's had two cases, one of which is a misdemeanor.
For purposes of arraignment, yes, Your Honor.
And then you pre-tried it? And
we did,
she's
Your
going
Honor.
to plead the failure to report. And they're going to dismiss the improper lane use and leave the scene, true?
That's correct, Your Honor.
Is that what you want to do, ma'am? If you plead guilty to failure to report, possible penalties are up to 100 fines, 90 days jail, costs are all those. Do you understand that? Yes? Did you sign an advice of rights form here today?
Yes.
Did you read it and understand it?
Yes.
If you plead guilty, you'll be giving up all those rights and there will not be a trial. Do you understand that? In the charge failure to report a property damage accident, how do you plead?
I plead guilty.
On October 3 of 25 at 6:35 PM, were you operating a motor vehicle on Sibley near Telegraph in Brownstown?
Yes.
Were you involved in an accident?
Yeah.
With another vehicle?
Yeah.
And how did the accident happen?
It was an accident. They were brake checking me, so
Look at me, talk to me, keep your voice up.
they were brake checking me. So I ended up going around them and I thought I had it, but I guess I didn't. And
They were brake checking you?
Yeah,
This is somebody driving in front of you?
yeah,
Were you going which way on Sibley? Eastbound or westbound?
eastbound,
Eastbound. Okay, and they were brake checking.
yes.
And then you decided to go around in the left lane into the westbound lane of Sibley?
The turning lane.
And then how did the accident happen?
I thought I had it, get back in front of them, guess I didn't, and we ended up colliding.
Are you on probation or parole? You then left the scene, right? You did not wait for the police. Anybody force you to plead guilty?
No.
Anybody promise you anything to induce you to plead guilty? The plea is accepted, the failure to report. The leave the scene's dismissed. The improper lane use is dismissed. Look, I'm not saying restitution would be appropriate, but I'm going to set a sentence date and we're going to notify the victim. I'm going to give you a $500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. We need to make sure the victim's notified. Lisa, I know probation will probably do that, I believe, but what date can you do on the 5th, counsel?
I'll make it work.
What, November 5th at 8:30? Is that good, Lisa?
Yes.
All right, just make sure that they get the file to notify the victim. Come on back on that date. Where do you live, ma'am?
Copy.
Where's your office, Mr. Zayed?
Battlefield.
I'd prefer to have one of you guys either in your office or both of you here.
We'll make arrangements for one or the other, Your Honor.
Okay, good enough. We'll see you here then. Thank you very much.
Thank you very much.
Have a good day. Janah, Nevin Todd Janah, 25B1477555A and B and C.
Attorney Mike Baldwin, House Counsel, P 65417, on behalf of Mr. King Officer, can you please state your full legal name for the record?
Nevin Janal.
So we got a failure to yield commercial vehicle, no insurance, and leave the scene as I understand it, he's going to plead to leave the scene of a property damage accident, and they are going to dismiss the failure to yield and no insurance, right?
Right.
Is that what you want to do, sir?
Yes, Your Honor.
If you plead to leave the scene, the possible penalties are up to 100 fines, 90 days jail, costs are all those. 6 points will be added to your traffic record. Do you understand that?
Yes, Your
And
Honor.
did you sign an advice of rights form here today and read it and understand it?
Not today. I believe I did when I first came in.
Is this your signature?
I may have flipped it over and you signed
Okay,
it.
yes.
Yes, that was your advice. Yes, Your Honor.
You understand all your rights?
Yes.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, Your Honor.
To the charge, leave the scene of a property damage accident. How do you plead? Were you operating a motor vehicle on Freeland eastbound west of Allen in Brownstown, July 23 of 25 at 9:49 p.m.?
I was.
Were you involved in an accident
Yes.
with another vehicle?
Yes.
Did you then leave the scene without calling the police?
Yes, Your Honor.
So you
Yeah, it was.
It took, yes.
how'd the accident happen?
It was very slow moving. He was waving me to, my headlights were out or off on my car. They weren't turned on. And, I clipped them
And then you left the scene.
and I was left.
Are you on probation or parole?
No,
Anybody force you to plead guilty?
no, Your Honor.
Please accept it to that charge. Files B and C are dismissed. That is, count 3 is no insurance. Count 2 is commercial vehicle failure to yield. Those will be dismissed. And I'll accept the plea as to count 1. We're going to set it for a sentence date, November 5th. Notify the victim, personal bond, $500. You cannot leave the state. You cannot violate any law. You must appear in court as directed. So we'll do it at the same time as I just told the other gentleman I'm going to sentence him. Do you have any questions?
No.
So you're going to go down the hall, get your notice. I'm not ordering a pre-sentence
Yes.
report. And then you come back, okay?
Okay.
Best of luck to you. Thank you.
Yeah.
Antoine Torrance, 25B149389, A and B and C, And I also have 25B149398. And then I also have a sentencing here.
Yeah,
On file 25B148681A. Sir, your name?
Attorney Mike Baldwin, House Counsel, Judge, as to 898B, C, and 98, today is the date and time set for arraignment, pretrial for purposes of arraignment. On those four matters, my client stands mute and waives formal reading of the general information and complaint. We're asking that this be scheduled for a subsequent pretrial date.
Not guilty pleas are entered. We have a possession of a controlled substance, open end talk, super drunk. And no ops. I'm entering not guilty pleas on all of those. Where does your client work at?
I'll allow him an opportunity. I didn't see that. He's unemployed for 2 years. He received Social Security disability. He's also got to go before the Forensic Center. He's got a date of October 23rd tomorrow to report to a law firm. There's some judicial reason. It looks like he's in front of Bradley Cobb on a forensic appointment case. So it looks like he's going in for a forensic
I
induction.
need a bond sheet.
Judge, on the 81A case, today's the date time set for sentence.
I don't want to talk about that. I'm setting a bond yet, still.
Okay, yes.
He's got a horrible record. He's got a prior drug charge from 05. He's got a prior impaired charge from 12. He's got another drug charge from 25. He's got a jury trial scheduled on another drug charge next year. I don't know,
He's shown, first of all, he's showing up for every court hearing. I just want to make sure that I'm aware of. There was one bench warrant on the Register of Actions for 98, but because he was incarcerated. Yes, thank you. 81.
He had crack and marijuana. They're recommending jail.
They are. And Your Honor, we discussed this. He went in May of last year, May 29th, I think was the incident date. For reasons which I can't figure out, he was apparently not arraigned on my case. He wasn't arraigned until July 2nd. And
What case?
On the, this case that we're on, Judge, the 81A case.
No, he wasn't arraigned until August 27th.
Well, there was a
He didn't show up on July the 2nd. He didn't show up on July 16. He posted a bond on July 30. He was arraigned on August 27th. Then we adjourned it to September 10th and the 24th. And then he pled on the 24th.
The rub is this. He was picked up on May 29th, the incident date. He went into Wayne County Jail on the 30th of May, and he sat in there for 2 months. And the question is, why wasn't he arraigned?
And that's why I didn't even know the court date. And
he was oblivious.
Well, he must have been on another case.
That's what I explained to my client that it looked like to me, but it doesn't change the fact that the incident happened on the 29th. He's brought into custody. So they know that there's this allegation of a controlled substance charge, and he's not arraigned, so he's sitting in jail without jail credit. We would ask that the court, and I'm going to respect my client's request, I'm going to ask the court to give him any jail credit that he's entitled to with this court.
Well, he's going to have to provide us with some proof.
That he was in jail?
Yeah, hang on a second. Slow down.
Now, my client is asking me to ask the court, and I will, for probation.
Well, I get it, but you know what I'm going to do? I'm not going to sentence him today.
And wait until we do the.
He can get his proof, but on this case, I'll give you a personal bond on this drunk driving. But you're not going to be released until you're fitted with a SoberLink device. Do you understand what I'm saying? Yeah, you're gonna have to be fitted with a SoberLink device.
It is a bond condition.
As a bond condition. So I'll give you a personal bond, but you're gonna be, sir, you're gonna be taken downtown. And you're gonna remain in custody until they can fit you with a SoberLink. This is crazy. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. Slow down. Let me talk.
He wants.
Hang on. I'm not done.
Yes, Judge.
AANA 4 times a week, not to be released until fitted with a SoberLink device.
Yes, Judge.
What's the problem?
First of all, let me finish something.
And then I'll I'll set a pretrial on this and I'll set the sentencing date over on the other one.
So that, Your Honor, I'm gonna just emphasize to my client, I know.
What does he want? He's agitating me right now.
I'm sorry, sir, but like.
What do you want?
If I.
He wants to go to his forensic
I don't
appointment.
think this, but I'll get in trouble for this
When is that?
tomorrow. And that's what I was trying to pay.
You don't have the money to get your own SoberLink.
I do have money. I have money, sir. If you could just give me another day, I could.
No.
Tomorrow, after this appointment, so I don't violate my.
Looks like he's got to be, at the forensic evaluation.
Here's the
On
problem.
October 23rd at 9 a.m.
He's gonna have to deal with somebody else because, sir, I don't trust him. Knock it off. Do not argue with me. Otherwise, I'm setting a real high cash bond here. I am not about to argue with you. You're awaiting sentencing and you go and pick up a drunk driving. Your record's horrible. No wonder they're recommending jail. They do not give me enough money to argue with people, and I'm not starting today.
I'm sorry.
Have a seat. That's the order of the court. We're going to give them a new date, Lisa, as soon as we can on these. These are out of Brownstown. So what day do you want to give them? In other words, I'm adjourning the sentencing to that date and the pretrials on the other case.
Judge, my understanding is once he's fitted with the SoberLink, he's ready to go against personal bond.
Correct. Sir! Shut up and sit down.
That's my, yeah, that's it. Yeah. You do that.
Go ahead, Lisa.
November 5th at 8:30.
November 5th at 8:30. Those are going to be the dates.
Yes, that's.
What was his bond amount?
I'm setting a 2,500 personal on the new cases, but I'm not going to let him be released until fitted with a GPS, until fitted with a SoberLink device. So I'll set that November 5th at 8:30. And we're going to have to do a minimus that indicates that. And I hope they can fit him with it today, but there's just not enough confidence that I have that he's not going to go out and do something else. So that's what I'm doing. Deborah Jan Daly, 25B1494888 A and B.
Your Honor, I believe Mr. Mason is in with Judge Coleman's Hessen's courtroom. If the court could.
No, sir. We have $250 in reimbursements and we have 41 days of jail time credit. Does that sound right to everybody?
Yes, sir. It does.
Mr. Hartman, on behalf of the state?
Nothing else, Your Honor.
Officer Torek?
Nothing more than discussing, Chair.
Mr. Staten?
Nothing further, Your Honor. Thank you.
What do you want to tell me, Mr. Brown?
I'm sorry that this happened, but I'm thankful for the opportunity to, I was already on my recovery journey. This just opened my eyes to a few more things. I'm just thankful to still be on that journey.
Well, here's the thing, Mr. Brown. I do not think that this case is going to end very well. I am hopeful that it will, but it seems like we're in a cycle that at some point you need to break. but that's where we're at. I am going to give you the opportunity to get this done out in the community, so I'm going to put you on 3 years of community control. I'm going to impose upon you the standard rules of community control. You're going to enter into and successfully complete outpatient drug and alcohol treatment, probably IOP right out of the chute. And I'm going to give you credit for the 41 days that you've already done. I'm not going to impose a fine. I am going to impose the cost plus the $250 in reimbursements. If you violate the terms of your supervision or you leave the state without permission, I can sentence you to up to the maximum penalty in the case, which is 18 months in prison, plus the optional period of post-release control of up to 2 years. Is there anything else we need to do? Anything that I forgot?
Just that his medical card is approved, he has to go through dispensaries and not through process.
Yeah, a medical marijuana card means that you obey the medical marijuana law requirements. It's not a license to go get pot wherever you want to. So I'll approve your medical marijuana, even though I don't think it's a great idea. It works for some people, so maybe you're one of those people it works for. Just got to do it right. All right, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript, or to pay the cost, they'll all be provided to you without charge. Good luck to you, Mr. Brown.
Thank you, sir.
Thank you, Your Honor.
Sorry, Your Honor.
Oh.
You also want to see still this?
Oh, yeah, that makes sense. All right, that's all.
Please temporarily pass the matter.
Ma'am, come on up here, ma'am. I'm just gonna get you out of here. You've been waiting all day. Your name?
Fill in with.
Good. Fill in right here. Your name? Your name, Mr. Baldwin?
Jan Davis.
Attorney Mike Baldwin filling in with permission for Mr. Mason.
So you want to stand mute, wait for my reading? Is that what it's going to do? Not guilty, please entered. I'm going to give you another court date. November the 5th. At, what do you think, Lisa?
11.
At 11 a.m. Okay, ma'am? And you're going to have to fill out a petition for a court-appointed lawyer going forward, okay?
Okay.
Thank you.
All right, and what was her bond, Judge?
I'm giving her a $500 personal bond. You cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. Do you understand all that?
Yeah.
All right, so we'll give you a petition for court appointed, fill it out, then go down the hall, get your notice. Wish you well. Jonathan Patrick Johnson. Jonathan Patrick Johnson, 25B1489318.
Attorney Mike Baldwin, counsel, D65417.
Mr. Johnson, you have to unmute and tell me your name, sir.
Jonathan Johnson.
Good morning to you.
Good morning.
All right, so we have a prior, and you are from Detroit, right?
Yes.
You've been considered enough to allow him to show up and he
I know, but I'm thinking he needs to get into sobriety court.
I saw that as well. We had a little talk about his past history with alcohol. And I did not discuss that with him, but I am in total agreement. My concern is I believe he may have employment that helps, enables him to work from home.
Mr. Johnson, I want you to listen to me.
Yes, sir.
You need to get into our sobriety court. This is 2 within 1 year. In fact, year 2 within 8 months. If you don't want to get into sobriety court, I'm going to have to send you to jail. So you're going to have to figure out a way to get here at least every other week for sobriety court review hearings. If you can't do that, then I don't know what to tell you. You're going to end up in jail. What do you want to do?
I guess sobriety court.
You're going to be able to get here, right?
I can try.
Well, I don't want you to try. I want you have to understand, if you get in this court, sobriety court, you're going to have to get to Woodhaven at least every other week. You understand what I'm saying?
Yes, sir.
Are you going to be able to do that?
Yes, I can.
We'll adjourn this to November 19th, Lisa, and we'll see how he's doing. You wait right there. We're going to have you talk to a sobriety court PO.
Okay.
November 19th at 9:30 in the morning, we can do in person. You're going to have to show up for that, okay? That's going to be in person. You're going to wait, and we're going to set up somebody to talk to you about sobriety court, explain everything to you. And if you decide to go that route, you're going to file or comply with all their bond conditions. Do you understand that? So you're going to be immediately in treatment, immediately going AA, immediately testing. Do you understand that?
Yes.
All right. So stay right there. I hope you'll do this. This will be good for you. You'll be glad you did. It's a lot more.
In line to what I discussed with him, Your Honor, and I think that he realizes the reality of the situation better now that you've presented that.
Do you understand everything, sir?
Yes, sir, I do.
All right, Lisa, can you call over to probation? Or do you want to call 245 and find out?
Can you call Deborah Daly back? We need a longer term date, Judge. Please. I didn't say it because I didn't know. It's something Mr. Mason discussed with her, and it didn't get on the record.
All right. All right, just wait right there, sir.
Okay.
Is J. Edward Clay here?
On Zoom, Judge, he's in the hospital, is my understanding.
He's in the hospital?
That's what I was told. I'm bringing him in right now. There's also a subpoenaed witness out there.
J. Edward Clay, 25I-76087A, B and C. Your name, sir?
J. Edward Clay.
Are you doing okay? They said you're in the hospital.
Yeah, I'm getting the treatment back. I had back surgery and I had got an infection and I'm hurting. I'm in pain, actually, Doc. Your Honor.
Okay, are you in a position to proceed on this today?
Not really. I'm not, because they got meds in me and no, I'm not.
Ma'am, are you, what's your name?
Mine?
Yeah, are you on this case?
Yes, I am.
What's your name?
Lisa Fell.
Okay. So you want to go with a hearing, sir? You don't believe you had anything wrong? You don't believe you're responsible on these?
I wanted to stand mute on it, Your Honor.
There's no standing mute. It's not a not guilty plea. It's a civil infraction.
Oh, okay.
If you want to have a hearing, we'll give you a hearing. But it's been going on quite a while. Ms. Day, please. Yeah. Thank you.
That's my point.
It's been going on quite a while. I got to move this case on here.
Okay.
If you don't think you and the prosecutor can resolve something, fine, but.
There's your acupuncture. You can try some Toradol to get the inflammation down.
Okay, thank you, Doc. Thank you. Okay, I'm sorry, Your Honor.
Dad, got to move this case along. It's been going on way too long for me. I'm supposed to have these done quickly. It's been going on for 2.5 months. Listen, if you don't feel well and you want to have a hearing, that's fine. I'll give you a hearing in 2 weeks. Otherwise, I think you and the prosecutor maybe can talk this over and see if you can resolve it.
Okay, yes. Can we do that, me and the prosecutor?
Have you talked to him yet?
Yes, Your Honor.
Your name?
Matthew Wayne on behalf of Rosehill Township, Your Honor.
What is it?
We had an opportunity to speak. My understanding that Mr. Clay, again, he did not say this to me. It's my understanding, my interpretation of Mr. Clay is aware of his responsibility for this action. However, I understand that there's a possibility of civil litigation. That's what Mr. Clay represented to me, and then is hindering him from getting pleadings back, or rather coming to some kind of acknowledgement of responsibility.
I don't know what to tell you. What do you want me to do?
Can we just adjourn it? I can talk with the prosecutor the next couple of days.
Listen, I'll adjourn it. Why didn't you tell me that you had this going on?
I didn't. I had it done last week, and then this is the consequences of it. I've been in so much pain. I can't walk. I've been in a wheelchair, so I've been in the hospital, and they're trying to get me back walking.
Yeah, I can't speak to Mr. Clay, but as far as Ms. Bell, the victim, this is the second time she's been subpoenaed. She has hourly employment that she's missing out as a result of this. We received, we're in touch with the court, and we received indication. So Mr. Clay apparently did attempt to retain counsel as the original reason for the adjournment.
When she withdrew?
Yes. There we are, the date and time scheduled.
Yeah, I'm gonna go ahead. I mean, you seem fine to me. I'm gonna go ahead and proceed with this hearing now.
Okay, that's fine.
Okay, let's call, I have 25I-67608-7, A, B, and C. Lisa, you can move Ms. Day's court hearing date.
4 weeks from today, please. That was what Lisa was saying. Yeah.
Go down the hall
Shower.
and she'll give you a new date, okay? All right. Mr. Clay, your name again.
J. Clay.
All right, counsel, your appearance again.
Good afternoon, Your Honor. Matthew Wayne on behalf of Rosehill Township.
All right. Do you wish to give an opening? I have 3 charges. I have no license, vicious act,
This one's
and it says duty to notify police.
just because of the risk of leaving.
What does that mean?
Kind of the injuries, Your Honor, and kind of circumstances.
All right, well, okay. So, Mr. Clay, do you want to proceed to the hearing, or do you wish to admit responsibility to any of those?
I'm gonna proceed to the hearing.
All right. You want to just call your first witness? Do you waive your opening?
Yes, Your Honor.
Do you waive your opening, Mr. Clay?
Yes.
All right, call your first witness.
Thank you, Your Honor. The township calls Lisa Fell.
Ms. Fell, state your name.
Lisa Fell.
Raise your right hand. You solemnly swear affirm under penalties of perjury, the testimony you give in these proceedings will be the whole true self you got.
I do.
Okay, go ahead.
Good afternoon, Ms. Fell. How are you?
I'm good. How are you?
I'm fine, thanks. What do you do for a living?
I work as a delivery driver for Amazon.
And how long have you been in the employ of Amazon?
2 years.
I'd like to take you back to on or about August 6th of 2025 in Rosehill Township, County of Wayne, State of Michigan. Did something happen that day that brought you here today?
Yes.
Tell me what happened that day.
I was attacked by a customer's dog.
Okay, so if I go back for a second, so you were in Rosehill Township that day?
Yes, sir.
Okay. And the time of the dog, the attack that you're talking about, would this have been approximately at 4:30 in the afternoon? Does that sound about right?
Yes, sir.
Okay. And if I told you you were in the vicinity of 28790 Coleman Drive in Rosehill Township, does that ring a bell?
Yes, sir.
Okay. Why were you at that residence that day?
I was delivering packages to that address.
Okay. So you're in your delivery vehicle, correct?
Yes.
And you get to the residence
What do you do then?
I make sure there's no dogs on the delivery app. It'll notify us if there is. I gather the packages. I get out of the van, and halfway down the
Stop you for a
driveway.
second.
Yes.
So just so we're clear, we're talking about what happened that day at that residence, right?
Yes, sir.
Okay, sorry, go on.
I got about halfway down the driveway when a dog just charged at me out of the garage.
So, sorry, out of the garage, 28790 Coleman Drive? Okay.
Yes, sir.
What happened then?
I froze. I didn't know if the dog was going to attack me, or approach me friendly, but it just darted at me anyway. It jumped on me immediately and immediately attacked me, biting my leg. And I threw the packages down. I threw the phone down and I started screaming and I ran back to the van. About halfway to the van, I looked to see if the dog was chasing me. It was still where it bit me. So I assumed that maybe it had an electric shock collar on or something. But I got to the van and I was holding my leg, crying. I immediately started calling my dispatcher and I heard someone asking me if I was okay, asking if the dog bit me. I came up to the front of the van because I had ran to the back of the van where I felt safe. So I walked up to the front and okay.
Sorry, Ms. Bell, if I could stop you for a second. So you said the dog attack, the dog bit you.
I'm
Correct?
sorry, could you repeat
The
that?
dog bit you, right?
Yes.
Okay, go ahead.
How many times did the dog bite you?
He latched onto my leg and kind of pulled my skin. I'm assuming he bit me once, maybe nipped me a second time.
Did the dog draw blood?
Yes.
Okay. Did you perform any first aid upon yourself?
Sort of. The customer came out and told his son to grab some peroxide and paper towels. So I kind of cleaned it up a little bit.
Okay, the customer, is that individual on Zoom today?
Yes.
You can see names. What's the customer's name?
His name is Jay Clay.
And the person who's on the screen with the name Jay Clay, that's the same individual that was at the house that day?
Yeah. Yes, sir.
Okay. So you said there was some peroxide and some what?
Paper towels.
Okay. And what did you do with those?
I poured it on my leg and wiped off the blood and held it on my leg.
Why did you have to hold it on your leg?
It was just blood coming out.
Okay, so it wasn't like a little bit of blood, like a trickle.
No, sir.
How would you describe the blood coming out of your leg?
I would say pouring, but it was a little less than pouring. It just kept coming out.
Okay. What happened then?
In the middle of talking to my dispatcher and explaining what happened and talking to Jay, he repeatedly kept apologizing to me and telling me he meant to put signs up. And my dispatcher asked if he needed me to be taken to the emergency room or if I could drive myself. I told him I wanted to get there as soon as possible, so I wanted to drive myself.
Okay. And was that the end of the incident?
Jay then offered his contact information, and I took it down. I took his name and his phone number.
Okay. And then what did you do?
I I left and I went to the first choice urgent care in Romulus.
And were photographs taken of your injuries?
Yes, I took them as I was on the phone with the dispatcher at the address. And then I took them at the urgent care. I took a lot of photos.
Okay. All right. No further questions. I would like to reserve the right to recall a witness.
Okay.
Thank you, Your Honor.
You have any questions of her, Mr. Clay?
No, I have no questions at all.
Call your next witness.
Dr. Call Julie Cordes.
Sir, do you acknowledge that the dog was not licensed?
You talking to me, sir?
Yes, sir.
Yes. I'm sorry. Could you rephrase?
That's all right. Raise your right hand, Ms. Cordes. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God.
Ready?
Okay, go ahead.
Good afternoon, Ms. Sports. How are you?
Good, how are you, sir?
Fine, thank you. What do you do for a living?
Animal control and ordinance enforcement for Roseville Township.
And how long have you been in the employ of Bristol Township?
I think it's 13 years.
Okay. So I'd like to take you back to August 2025 in Bristol Township and County of Wayne, State of Michigan. Something happened that day that brought you here today?
Yes, sir.
Okay. Tell me what happened.
In my recollection, I believe it was the following day that Lisa Fell came into the lobby of the police department to report the dog bite. I recognized the name, Jay Clay. We had spoken before on another matter similar. Lisa described the incident as she did to you today.
Sorry, if I could say, you said a similar matter.
Mr. Clay lives on the south end of the island, and I had been out there for a previous dog bite incident as well.
At his address?
Yeah, it was a couple of years prior, I think 22.
Okay. Do you recall whether that involved allegations of a vicious animal?
I'm not sure the term vicious was used, but it did in fact bite a neighbor, a young female, and there is a report on file. I couldn't remember if we had taken enforcement action at that time. I think the dog was younger possibly at the time, and we did do a report for documentation purposes.
Okay. So when this fellow came in and filed a report, or if she wanted to file a report, want to make a report, so did you take that report?
Yes, I did.
Okay. And what was the ultimate result of you listening to her as to her account of what happened?
Basically, it was just documentation at that time. I wanted to meet with Mr. Clay and get his version of events. I do recall, I took one photo in the lobby and we talked about her wound and how she was feeling that day. Was it better? Was she in pain? And she said that it was still bleeding, and you could see that it was bleeding through the dressing. So apparently it was a pretty deep wound.
Can I just ask a question? Did you check and see whether this dog that Ms. Fell was licensed?
Yes, sir.
Was it licensed?
No, sir.
Did Mr. Clay ever notify your office or you in particular of this dog bite?
No, sir.
She cited 20-14. It's actually 20-12, and it makes it incumbent upon the person who's bit by the animal or the owner to notify the police department. That's all the other information you need to hear. So if you can't get it from her and you want to get it from somebody else, fine. If not, that's fine too.
We'll just move on. That's all right.
Yeah, I don't really need to hear much more though, but go ahead.
So did you ultimately issue a citation to Mr. Clay? Is that correct?
Yes, sir.
Okay. And how did you present that citation to him?
In person, I believe.
Okay.
Not sure, but yeah, in person. And the reason for the multiple counts was because he had previously been informed to get the dog license. he had previously been informed to have the dog current on its rabies vaccination, which it was not either. And the fact that it bit another person and he didn't report it to the police department and left it to the victim to do so, was where that third charge came from.
So what is your understanding, again, in your capacity as a code enforcement officer and someone who handles these types of issues on behalf of the township? What constitutes a vicious animal?
A repeat at large, so an uncontrolled animal. In this case, subjective, I mean, the dog was on an electric fence collar, but who would know that? And there was no indication for Lisa to take any precautions, stopping her from reaching the front door. She didn't know there was a dog loose in the garage. Vicious, based on the severity of the bite, the picture of the wounds, if you have that available, it wasn't just a graze, it wasn't a single puncture wound. It was, she said that dog latched down and held on. And
What kind of dog was this?
I think it's a pit bull.
So again, you went to the residence and then after that, so you gave Mr. Clay the citation, is that correct?
Yes, sir.
Okay. Okay, so no further questions for you. I'm going to reserve the right to recall the witness if need be, Your Honor.
Any questions of Ms. Cordes, sir?
No, Your Honor.
You can step down. Thank you. Any other witnesses?
No, Your Honor.
Okay. Do you have any witnesses, Mr. Clay?
No, not at the time, Your Honor. I wasn't prepared. No, I don't.
All right, so what do you have any argument?
Your Honor, you heard today from the witness, you heard from the witness herself. If there's any question as to her credibility, you also heard from your code enforcement officer who testified regarding the injuries sustained by the victim. So no reason to doubt her credibility. Again, I think the township has met its burden.
All those. Sir, do you have any argument?
No, I don't. I can't really hear. I can't really hear that good because my background is so loud. So I'm just basically.
Can you hear me now?
I can hear you good, but I can't hear the lawyers. I couldn't hear the Officer Julie that well. So
why didn't you tell me when you were listening? Why didn't you say something?
Because, Your Honor, I am in pain. I told you I was in pain from the beginning. So I didn't know we was going to do the hearing today. I thought we was going to do the hearing another day, and we were just going to adjourn it. But since you just started the hearing, if that was the case, I would have just pleaded out from the beginning. But like I say, I don't have no argument. You can move forward with your judgment, Your Honor.
There's not any question here, but that you're responsible of not having a license for the dog, having a vicious animal. And even though there could have been an objection, there was testimony you didn't notify the police department. So on file E, I'm finding him responsible, file C rather, 87C, I'm finding him responsible of a violation of 20-12, which is a duty to report to police. So I'm finding him responsible on all charges. Can you pull him up? These cases are going to all result, these are ordinance violations under Grozios Township Code. They're for civil infractions. So I'm going to simply, per our chart, charge 135 on each of these. So you owe $405. Ma'am, you can seek restitution or you can have a lawsuit if you want. I can't really order restitution in a civil infraction case, okay? So I want you to understand that. Sir, do you have the $405 to pay today?
No, I don't have it today. I'll probably be still here in the hospital. Can you give me a week?
I'll give you until the 7th of November. Is that good?
Thank you, sir.
Listen, if you don't have the money, no problem. Call the court on the 7th or before, and I'll be glad to give you an extension if you need one, okay?
Thank you, Your Honor. I appreciate it.
Thank you very much. Good luck.
Thank you. Take care.
Ms. Stahl.
Thanks a lot. Are we done?
Just got motions.
I'll do them later. All right, thanks you guys. Thank you very much.
You're on.
Thanks, Fly.